before we crack on with business,
Sorry.
before we begin this, I'm wondering if it would be possible to just raise a matter that I emailed States members this morning to suggest to be helpful and try to lighten the load at the next sitting, that I ask if I can bring forward P50, which is the proposition relating to appointing the members of the Rent Tribunal to the end of this sitting, because it's okay in terms of the work we're doing there to propose that a bit early, and if it helps members not have to deal with that at what's going to be a very busy sitting next time round, I'd be happy to do that, and most members who responded said they were happy with that, so could I propose that?
I haven't seen the email and I don't have the item in front of me, but am I right to assume that it's been lodged for the sufficient amount of time, or are we going to need to reduce the lodging period for it to be taken at this sitting?
I can't recall off the top of my head, but I will propose reducing the lodging period if it requires that.
Well, I think this is the best moment to deal with that. So the proposal is to bring forward P50 from the order paper for the 24th of March to this meeting. Is that proposal seconded? Yes. Does any member wish to speak? If no member wishes to speak, then we close the debate. If members would be in favour of that proposal, if they would kindly show. Those against? I think that's fine. We'll add it to the end of the order paper for this sitting then, Deputy. Thank you.
Thank you.
So we return to P8, the draft crime strangulation Jersey law and the principles. I don't have anyone listed at the moment to speak. Does any other member wish to speak on the principles? Deputy Ayer.
Sorry, if I could just have a clarification from the AG.
Yes, if you want to ask a question.
Yes, it's just that before lunch the AG mentioned that there was a up to a maximum imprisonment term. But I noticed that Article 1.1 says a person commits an offence and is liable to imprisonment for a term of 10 years. And I wonder if I'd misinterpreted that. Thank you.
Mr. Attorney.
That apparently is modern drafting practice, and it means up to a term maximum of 10 years.
Does any other member wish to speak on the principles? In which case, I close the debate and I call on the Minister to reply.
Firstly, whilst it's in my memory, I'd just like to address the matter raised by Deputy Balash as to why this needs to be a standalone offence. Introducing a standalone offence of strangulation allows the severity of this form of violence to be appropriately recognised in legislation as a distinct and often more serious form of violence than other forms of violence that can be prosecuted under common law or grave criminal. Because we don't have a specific offence of strangulation, we can only prosecute strangulation under existing assault offences, because these offences are intended to capture a range of violent acts. They hold a range of sentence lengths. By creating a separate specific offence of strangulation, we place the act of strangulation on its own statutory footing. This means that we are able to specify a penalty of up to 10 years imprisonment and a fine for this offence. This ensures that the penalty for the offence appropriately reflects the seriousness of the act. It is also worth mentioning that offences under grave and criminal assault that have been prosecuted within the courts, there are some that have been found not guilty, and therefore the offence then drops to the offence of common assault, which of course is a fairly is a significantly lesser offence, mostly because, of course, injuries aren't always so notable in relation to strangulation, because some of those can be actually long-term. So I just wanted to make that point, and that is why it was considered a good idea to have a separate offence. In relation to the other matters arising from the questions asked, we are planning and preparing to introduce a training package on the strangulation and its harms for health workers, the police, and for teachers. We're also introducing, and as I said, have already started speaking to young people about the content tailored into the understanding and the needs of these offences. A working group has been set up within health and care to establish a forensic medical pathway for responding to victims of strangulation so that they can get the treatment and care they need, and the correct evidence to support prosecution can be collected. This will, of course, need funding and should be considered in the 2027 budget. There are clear standards outlined by the Institute of Strangulation in the UK on how to respond to this in relation to the forensic pathways. The relevant training, again, will be provided to deliver that to hospital staff, police, forensic, medical examiners and prosecutors. With any new offence, particularly in relation to where medical evidence is required, quite often there will be training. But rest assured, our forensic examiners are already very experienced individuals in the field of domestic violence and a range of offences, and can pick those offences out. And I think any of those of you who were at the Frida the other day will have heard the speech from Lady Kidd. And I think that is, quite evident that these things are identified by medical practitioners. And so I think that is an essential part of all of this, but the training will need to be given. And I know that, again, the scrutiny panel talked about funding. And as I said from the outset in relation to this law and these laws, my view was quite straightforward from the start of my term of office, that there was underfunding in certain areas, and we need to address that. These laws are a way of actually putting a price tag on something, if you like, and saying, we need to address this, we need to make sure that people are trained properly. And this is something that should happen all the time. It's not something that should just happen because we've done a review of something and we suddenly realise that we're falling behind. So I think people need to remember that when we do this, there is implications. And so when we bring forward laws, we need to make sure that those implications are identified and well addressed. And as I said, it wasn't able or appropriate to be able to bring the money into this budget because we have to see how things pan out, as the Treasury Minister said. And so I think from that aspect, I thank people for their comments, and I continue with the proposition. Thank you, Ma'am.
Those members who are in favour of the principles kindly show.
Appel, please, Mark.
The appel's been called for. Ask members who are in the vicinity to return to their seats. And ask the greffier to open the voting. If all members have had an opportunity to cast their vote, I ask the greffier to close the voting. And I can announce that the principles have been adopted. 40 votes pour, no votes contre. Deputy Catherine Curtis, does your scrutiny panel wish to scrutinise this matter? We come to the articles, and there is an amendment to Article 1 from the Minister. Minister, do you wish to propose the articles as amended?
Yes, please, Ma'am.
Are members content for the articles to be proposed as amended? How do you wish to propose them then, Minister?
En bloc, please, Ma'am.
Are the articles seconded?
Yes, sir.
Does any member wish to speak on the 3 articles? Deputy Andrews.
Thank you, Ma'am. I must say I still feel very uncomfortable with the inclusion of consensual strangulation. There will be some women out there who are in relationships and their partners are the ones who are very domineering. They're the ones who hold a great deal of control in the relationship, and they could potentially be quite forceful in wanting certain things sexually, and the partners are in a very susceptible position, and that they feel that they've got no choice but to do things that they feel very uncomfortable with. and that's something that hasn't so far been mentioned in the debate. And I think it's important that I do raise it, because I think there are many women who've unfortunately gone through ordeals, and it's bound to have a profound effect on them. And I think we need to also recognise the significance that has and the impact on those individuals. So I will be supporting the articles. However, I wouldn't be surprised if there are refinements in the future, and that potentially could be due to things arising as a matter of concern, because incidents are being reported to the police, and therefore further consideration may need to be given to the law in future. Thank you, Mark.
Does any other member wish to speak on the articles? Honourable Greville.
Thank you, ma'am. I was not rising as the Vice Chair of the Scrutiny Panel. I'm rising as a parent to give the Assembly a practical example of how this can affect somebody's life. My son performed a musical in the Opera House at the end of January, and he stated in that wonderful piece that he'd been strangled as a boy at school, and my wife and I had no idea, which meant it left no marks at all on his throat. He was strangled to the point at which he passed out, and he shook visibly for 3 weeks after that and went through a bout of depression as a result. And it affected him quite deeply for many years, and he still has flashbacks 18 years later. But that could have affected his career as well, ma'am, because, of course, as you may or may not know, he's a performer and a singer, and it dropped his voice by an entire tone. So that could have affected his way of making a living as well. So I just thought it might be good to voice an actual example of how these things can affect somebody's life and how tragic it could have been. Thank you, ma'am.
Deputy Howell.
Thank you, Ma'am. I was asked before lunch by Deputy Dublé if I could say what was going on. I think the Minister has already indicated what's happening. The GPs are receiving mandatory something called IRIS training, which is identification and referral to improve safety. So they have to do that. There is other training for other professionals, but it's ongoing, and I'm sure there's always more to do. But it is, I think it's for, we need the first lot responders to really be aware. And I just thought I'd say that it's recorded that 50% of adults have no visible injuries, but there are other signs: loss of consciousness, incontinence, hoarse voice, as the constable has said, pain on swallowing, etc. So it's important, really important, that all our staff, health staff, are trained. Thank you so much, Ma'am.
Thank you. Does any other member wish to speak on the articles? Conatable of St Saviour.
Thank you, Ma'am. I would like to add to that list that with strangulation, even in a playful sense, I would say, let's not go into details, can cause extreme bloodshot eyes and in certain cases permanent eye damage. Thank you, Ma'am.
Does any other member wish to speak? If no other member wishes to speak, I'll close the debate and call upon the Minister to reply.
Thank you, Ma'am. Consent is defined as free agreement in the Sexual Offences Law, Article 2. If it is coerced, then it is not free agreement and does not meet the legal standard of consent. As I explained earlier, as a statutory of the European Convention on Human Rights, Jersey has a series of obligations relating to upholding our islanders' human rights. Article 8 of the Convention, Rights to Private Life, protects the right to personal development and autonomy. Sexual activity, of course, associated with individuals' exercise of free choice, and the question of consent to strangulation is typically discussed in the contents of sexual relations. The inclusion of a strangulation offence as a consent defence allows us to strike a balance between deterring islanders from harmful behaviour and respecting their personal autonomy. That is why the consent defence has been included in this law. Including the consent defence in this law has also allowed us to place clear restrictions on the use of this defence to protect against the misuse of the provision. And it is quite clear within the law that it is very limited where the defence would be able to be used. And I may ask, Ma'am, if the Attorney General may assist with giving members the legal perspective as opposed to just mine.
Mr Attorney, are you able to assist?
Well, I think the Minister has comprehensively explained the legal position, which is that the defence is there to safeguard those who engage in certain forms of conduct and do so by consent, where that conduct does not cause injury or serious harm. And the thinking behind that it is in part engaging the Article 8 right to a private life. I think the Minister's really explained it.
Thank you, Ma'am, and I call for the appel.
Appel is called for. If members are already in their seats, I ask the greffier to open the voting. If all members have had an opportunity to cast their vote, I ask the greffier to close the voting. And I can announce that the articles as amended have been adopted. 43 votes for and no votes contra. Do you wish to propose the matter in third reading?
Yes, please, Ma'am, and I have nothing further to say, but obviously we'll wait others. Thank you.
Is the matter seconded in third reading? Yes, ma'am. Does any member wish to speak? No members wish to speak. We close the debate. Those in favour of adopting the law in third reading?
Can I call for the appel, please, Ma'am?
Appel's been called for. I ask the greffier to open the voting. All members have cast their vote. I ask the greffier to close the voting. And I can announce that the draft crime strangulation Jersey law has been adopted in third reading. 43 votes for and no votes contra. The next item is the Draft Crime Public Order Jersey Amendment Law 2000, P9, lodged by the Minister for Justice and Home Affairs. The main respondent is the Chair of the Children, Education and Home Affairs Scrutiny Panel, and I ask the greffier to read the citation.
Draft Crime Public Order Jersey Amendment Law 2000, a law to amend the Crime Public Order Jersey Law 2024 to amend the offence of threatening to kill, rape or cause serious physical injury. The states, subject to the sanction of His Most Excellent Majesty and Council, have adopted the following law.
Minister.
Thank you, Ma'am. This is the final law to an amendment, this is the final law, is an amendment to the existing public order law. It is a simple amendment that seeks to ensure that our justice system is better able to respond to threats to commit the most serious sexual offences. Under the current public order law, we have the Article 4 offence of threats to kill, rape or cause serious physical injury. In the course of my work to introduce the new package of legislation, our existing legislation was reviewed in detail and key criminal justice stakeholders were consulted at length. During this process, concerns were raised around whether threats to commit sexual offences other than rape might fall outside the boundaries of our existing threats offence. Threats of sexual harm and physical violence are, unfortunately, a very big part of the violence that women and girls experience. In 2025, more than 30% of the people that Jersey Domestic and Sexual Abuse Support Service supported reported that their abuser threatened to kill them or someone else. Following the United Nations Declaration on the Elimination of Violence Against Women and Girls in the 1990s, violence against women and girls has been internationally recognised as comprising of both acts of violence and threats of such violence. This has resulted in a gap between how our threats offence is constructed and the international understanding of what constitutes violence against women and girls. I have sought to fix that through this amendment by expanding the existing offence to include threats to commit other forms of sexual harm. This will ensure that threats to commit sexual offences that fall outside the legal definition of rape and might not meet the alternative threshold of serious physical harm are also captured within this offence. Whilst this amendment does not relate to a specific Violence Against Women and Girls Task Force recommendation, it certainly aligns with my commitment to update our legislative framework so that our criminal justice system is better able to respond to perpetrators of violence against women and girls. I therefore ask that members give their support to this final law, concluding that adoption of 5 pieces of legislation designed to address the crimes associated with violence against women and girls. This is a significant moment for our island. These 5 laws will make unprecedented protective measures available to victims and ensure that our criminal justice system is able to intervene with perpetrators earlier so that we can prevent violence against women and girls, not just respond to it. Thank you, ma'am.
Are the principles seconded? Does any member wish to speak on the principles? Deputy Catherine Curtis.
Thank you, Mum. So the purpose of this law is to include threats to commit sexual offences as part of the Crime Public Order Law 2024. Currently, threats to rape, kill or cause serious injury to a person are covered, but threats to commit a sexual offence, for example, a threat to sexually harm a child, are not covered under the Crime Public Order Law. The panel recognises that this was something that should have been in place and is pleased to see this development. The panel had asked again that a directive from the Attorney General be developed in relation to how children will be dealt with when they are subject to the draft laws, and I acknowledge the Attorney General's earlier comments. To sum up on this suite of laws, the panel thanks the Minister and her team and all contributors to getting these laws to this point. We do still remain concerned that structures may not be in place, considering that extra resource is required. There's no suggestion from the panel that the rollout of these laws should not be resourced. The concern is that the necessary structures may not be in place for the measures to be implemented. So I asked the Minister to explain how these laws will be implemented and whether some may require a phased approach, and if so, how this phased approach will work for the different laws.
Does any other member wish to speak? Deputy Stevenson.
Thank you, Mum. And it's just a quick point, hopefully, and really to raise some awareness and probably just speak to one of the points that was raised earlier about the need for education, and particularly with how we engage with our young people following new laws such as this and as laws change. And really it's the use of the word rape, because I recently was enlightened to this, shall we say, with some conversations that had gone on at a primary school. So we're talking about primary school level, and actually in the online gaming world at the moment, the word rape is sometimes used by people in gaming. I think I'm going to quote from what I've got in front of me, that it's used to describe a powerful and dominating victory in a game. And you sometimes hear people say in the gaming world, and bear in mind that people use headsets and talk to each other, and people they don't always know as well around the world, they may say things like, I'm going to rape you in this game, or I'm going to rape this person. So really it's an awareness raising thing. I'm not sure if the Minister has any comment to make on how something like that, would this offence require somebody to truly understand what the meaning of the word rape is? I think I also attended an event last year, I think, at which a case was discussed where somebody had threatened to rape somebody, and that person, I think, had special needs and had no understanding. They thought it to mean something else. So I'd be interested to know if there needs to be proven understanding of what the word means. But also I just share that to raise awareness, and particularly when we're talking about education, young people, what people have access to online as well, what our young people are talking about and coming into contact with. Thank you.
Does any other member wish to speak? no other member wishes to speak, I close the debate and call upon the Minister to reply.
I thank members that have spoken in relation to this particular offence and the chair of the panel. There obviously, as we've already said, will be a phased approach, and this can only really be in consultation with operational services, including all of those services, so that things can be brought in order that they can be actually implemented effectively. What, of course, happens is that these, if you look at a number of these things, as in the cases in relation to strangulation, stalking, and some of the other pieces of legislation, these are already being looked at and are already being investigated. But what we feel is that there will be likely to be an increase in that. So some of those offences people will already be trained and have an understanding of. But there is a full programme that will be required in relation to training to ensure that all of those agencies are all up to speed. And as I said, this will be something that will need to be discussed at the next, within the next government. What I would like to point out at this stage is the fact that from the point of view of funding, because it's been spoken about again, it was made quite clear to me at the start of my tender in this role that in order to gain additional resources to be able to deal with things, then the law needed to be lodged and the law needed to be in place. So one has to come before the other. That is why, as soon as I decided to lodge these 5 pieces of legislation, or the Council of Ministers did, that I was going to make sure that I wouldn't bring all of this legislation with nothing attached to it. As I said before, significant law over the last few years has had no price tag. So therefore, that is why I worked in this way. It was significant work that was done by all of the agencies in order to be able to analyse and work out what that cost was going to be. Particularly, and so therefore I'd like to thank the Treasury, as I said, and all of those other groups for the significant work that has been done to try and ensure that when these laws come in, that the funding streams can come in with it. So I think that's imperative to understand that. I can't change, Ma'am, what has happened in the past, but what I've done in relation to these laws is provide the Assembly with a knowledge and understanding of what all this means. In relation to what Deputy Stevenson asks about rape, I think it is a significant point, and that is what I would hope that any education that's provided to children and young people in schools will clearly identify exactly what that all means, because of course rape is sexual intercourse without consent, and so I think we already do provide that within our schools. However, in relation to what Deputy Stevenson was saying about people who may have some form of disabilities, those things would obviously be taken into consideration if that person was making those comments and their understanding of it. And the people who deal with those individuals would obviously know and be prepared to be able to make and adjust their thinking in relation to it. I think that is all I'd like to say in relation to the second reading, Ma'am, and I ask for the appel.
Well, the appel has been called for.
First reading, probably.
The appel has been called for. If members are in their seats, then I'll ask the greffier to open the voting. All members have had an opportunity to cast their vote. I'll ask the greffier to close the voting. And I can announce that the principles have been adopted, 44 votes for and no votes contra. Does the chair of the Children, Education and Home Affairs Scrutiny Panel wish to scrutinise this matter? How do you wish to propose the articles, Minister?
En bloc, please, ma'am.
Are the articles seconded? Yes, ma'am. Does any member wish to speak on the articles? No members wish to speak. Then I ask those in favour of adopting Articles 1 to 3, if they could kindly, the appell's been called for. I ask the greffier to open the voting. All members have had an opportunity of casting their vote. I ask the greffier to close the voting. I can announce the articles have been adopted, 44 votes for, no votes contra. We now move to third reading. Minister, do you wish to propose the matter?
Yes, please, ma'am. I'd like to propose the matter in third reading.
Is the matter seconded? Yes. Does any member wish to speak in third reading? Deputy Ward.
Just quickly, ma'am, just in schools, one of the things that really has developed over time is dealing with the notion of consent, which I think is crucial in this area, and teaching and certainly is not just in PHSE. I think I should say that it's not just PHSE where these things happen, but in form times where those relationships with form teachers are built up, and times and assemblies, etc. And I think that issue of consent is one of the key things that all of us have to talk to our young people about, because that's vital in dealing with these issues. Thank you, Ma'am.
Does any other member wish to speak on the law in third reading? No other members wish to speak. And I close the debate and call on the Minister to reply.
Thank you, ma'am, and I thank the Education Minister for his contribution in relation to what young people are taught in schools. At this point, ma'am, I'd like to just say that I would like to thank all of the agencies and individuals who supported the development of this important package of legislation from the start, with the money that was given, through to 3 Justice and Home Affairs Ministers, and it is an important package of legislation. The Specialist Victim Support Services, the Police, the Law Officers Department, the courts, and of course the Violence Against Women and Girls Task Force, and in particular their chair, who has kept my feet to the fire, that shone a light on the need for these important legislative changes. I would also like to thank the law drafter, because this is a significant piece of work and they have continued to work with the team, and also the policy officers. We don't have lots of policy officers, as people know, but they've worked tirelessly in relation to this legislation, but not only the legislation, the other recommendations, of which there was a significant amount. So it isn't only about the legislation that those staff have been working, they've been working significantly hard to be able to make sure that we'll be able to present a good report and be able to have a good amount of work that has been done during this term of office. Alongside, as I said, we've completed one review of the law, of the legal system, which has been completed and was delivered on the 11th of February. And we've now got the criminal justice review as well. So that is quite a significant amount of work. So I'd like to say thank you to all of those that have played that crucial role in bringing these laws in front of the Assembly today, and for member support.
Do you call for the appel? Very well, the appel is called for. Members in the vicinity should return to their seats, and ask the greffier to open the voting. All members have now had the opportunity to cast their vote. I ask the greffier to close the voting. I can announce that the legislation has been adopted in third reading, 44 votes for and no votes contra. The next item is the Draft Sanctions and Asset Freezing Law Jersey Amendment Regulations P10, lodged by the Minister for External Relations, and the main respondent is the Chair of the Economic and International Affairs Scrutiny Panel, and I ask the greffier to read the citation.
Draft Sanctions and Asset Freezing Law Jersey Amendment Regulations 2000. The states make these regulations under Articles 39 and 47A of the Sanctions and Asset Freezing Jersey Law 2019.
Minister.
Thank you, sir. These amendments help keep Jersey's sanctions framework aligned with the UK, which is important because Jersey implements both UN sanctions and UK autonomous sanctions. Staying aligned ensures our system remains clear, consistent, and meets our international obligations. Regulations 2 and 4 amend Article 1 to clarify the meaning of making economic or financial resources available indirectly to a designated person. This removes any doubt as to whether or not entities which are indirectly controlled by a designated person are covered by the meaning of making available to. These changes reflect equivalent updates made in the United Kingdom. Regulation 3 amends Article 32(1) by removing the requirement for financial institutions to have a direct connection with an individual before reporting knowledge or suspicion relating to designation or sanctions-related offences. This ensures that any relevant information arising during normal business must now be reported to the Minister, and Regulation 5 amends Article 36, expanding the categories of information the Minister may disclose, the bodies to whom the disclosure may be made where appropriate. This supports more effective cooperation with both domestic and international partners. And, sir, I commend the amendments to the Assembly.
Thank you, Minister. Are the principles seconded?
Yes, sir.
Thank you. Does anyone wish to speak on the principles of this draft law? Deputy Wilson.
Thank you, sir. I'm responding on behalf of the Economic and International Affairs panel. The Deputy Tadier sends his apologies. I would direct members to the comments paper that we've already prepared, but also to say that we are content with the Minister's approach to this. The panel understands that these regulations aim to ensure that sanctions implementations in Jersey remain appropriately aligned with the UK and that the Minister continues to meet international obligations. Based on the information provided in briefings, written correspondence and during the hearings with the Minister, the panel is satisfied that the proposed amendments strengthen the existing framework, clarify reporting duties for financial institutions and support Jersey's commitment to international standards. Accordingly, the panel is content and supports the proposals as proceeded. Thank you, sir.
Thank you, Deputy. Does anyone else speak on the principles of the regulations? Minister.
Thank you, sir. And as ever, I'm grateful to the Economic and International Affairs Scrutiny Panel for the work that they do in engaging with all of the legislation that the Department brings forward, and I'm grateful for their challenging but constructive approach to this legislation, sir, and I maintain the principles of the amendment, sir, and call for the appel.
Thank you, Minister. The appel has been called for. Members are invited to return to their seats. I'll now ask the greffier to open the voting. If all members have the opportunity of casting their votes, I ask the greffier to close the voting and announce that the principles are adopted unanimously, 43 votes for. Deputy Wilson, can you confirm that your panel do not wish to scrutinise the matter any further?
I can confirm that, sir, yes.
Thank you very much. Minister, how do you propose the regulations in second reading?
So as I've just been through the regulations in my comments on the principles of the amendment, I propose them en bloc and will endeavour to answer any questions accordingly.
Thank you, Minister. Are the regulations seconded? Thank you. Does anyone speak on the regulations in second reading? No. Those in favour kindly show. Thank you very much. The regulations are adopted in second reading. Minister, do you propose the regulations as adopted in third reading?
I do, if I may, sir. Thank you.
Are the regulations seconded in third reading? Thank you. Does anyone wish to speak on the regulations in third reading? Is the appel called for? No. Those in favour kindly show. Thank you very much. The regulations are adopted in third reading. The next item is the draft Controller and Auditor General Amendment Law lodged by the Chief Minister. The main respondent is the Chair of the Corporate Services Scrutiny Panel. I ask the Greffier to read the citation.
Draft Controller and Auditor General Jersey Amendment Law 2000, a law to amend the Controller and Auditor General Jersey Law 2014. The States, subject to the sanction of His Most Excellent Majesty and Council, have adopted the following law.
Chief Minister.
Thank you, sir. This amendment law strengthens Jersey's public audit arrangements by updating the Controller and Auditor General Law 2014 in targeted ways. So robust independent audit is one of the quiet foundations of public confidence. Islanders expect that spending is scrutinised impartially, that recommendations drive improvement, and that the Assembly and the public have a line of sight from money voted to value delivered. These amendments clarify appointment processes and governance arrangements for the CNAG, enhance reporting on findings and follow-up, and provide flexible tools so that the legal framework can evolve proportionately in the years ahead. The 2014 law established the modern public audit framework experience since then, including the CNAG's midterm reflections report of 2023 and stakeholder feedback, indicated several areas where the law can be tightened to align with recognised international principles and to keep pace with best practice. This proposition consolidates that learning into a focused amendment. The amendment law has been developed in close consultation with the CNAG. Both she and the Jersey Audit Office Board and of Governance have expressed their public support for the amendment law in the submission to the Corporate Service Scrutiny Panel. The draft law strengthens governance by requiring consultation with the Board of Governance on the appointment of the CNAG. Consultation will also be required when considering whether to revoke a CNAG's appointment. The statutory limitation of civil liability is extended to members of the Board of Governance, ensuring proportionate protection is in place consistent with their role. The draft law provides that those acting for the CNAG are treated in law as a CNAG staff, even where they hold states' employment contracts. This clarifies responsibilities and safeguarding independence in day-to-day operations. The draft law also confirms that the CNAG is not a state's employee by amending the 2005 States Employment Law Schedule, reinforcing institutional independence. Transparency is enhanced by requiring the CNAG to produce an annual report of findings that tracks recommendations issued and progress made, ensuring that there is a clear view of the CNAG's impact over time. A regulation-making power has been created, enabling the State's Assembly, when appropriate, to provide for the appointment of auditors or independent examiners for specified arm's-length bodies. So in conclusion, these are careful and proportionate improvements that modernise our audit framework while preserving the independence at its core. They will help the Assembly, ministers and the public to see more clearly how recommendations are acted upon, and they provide flexible tools for future needs. I'd like to thank the Chair of the PNAC for working collaboratively with the Government and Scrutiny for their work as outlined in their report. Sir, I propose the principles of the amendment law.
Thank you, Chief Minister. Are the principles seconded? Thank you. Does anyone wish to speak on the principles? Deputy Miles.
Thank you, sir, and I rise as chair of the Corporate Services Scrutiny Panel. So, following a private briefing on the draft law back in January, the panel agreed to undertake scrutiny of the proposals within the draft law, and we have presented a comprehensive comments paper which is available for members to read and which reflect its observations on the draft law proposals. In terms of just some of the key observations from our panel, a key focus for the panel has been on the extent to which government has implemented the recommendations made by the CNAG in the mid-term reflections. And the panel notes that government has not accepted and implemented recommendation 6 regarding the establishment of the Jersey Audit Office as a legal personality, or recommendation 15 to allow the CNAG to apply directly to the States Assembly in circumstances where the CNAG and the PAC chair might disagree on resourcing for the CNAG. However, the panel is assured that the draft law proposals implement all the recommendations relating to CNAG powers and duties in full, and that the regulation-making power within the draft law empowers a future States Assembly to fully implement the CNAG's recommendations in future, should that be their wish. In terms of independence, oversight and accountability, the panel focused on the extent to which the legislative changes proposed within the draft law have impacted on those arrangements for the CNAG and the Jersey Audit Office. We highlight that the draft law proposals include updates to the appointment process, CNAG staffing and employment arrangements, the limitation of civil liability of the Jersey Audit Office, and audit practice and reporting. And whilst the panel understands that the draft law does not currently have any financial or resource implications, these may be a consideration if in future the States Assembly chooses to invoke the regulation-making power, fully implementing the CNAG's recommendations. And the panel is further assured from the CNAG's feedback on the draft law that the proposals implement all of the 7 recommendations relating to independence, oversight and accountability in full. The panel have considered the consultation and engagement that took place in relation to the recommendations published in the mid-term reflections in the draft law. And whilst the panel understands that consultees that engaged with the CNAG's consultation were generally not supportive of the proposals, the panel acknowledges that the CNAG undertook a thorough process of consultation and highlighted main themes and key concerns raised by stakeholders. And additionally, the CNAG has informed the panel that she believes the concerns raised by stakeholders during the consultation can be addressed with sufficient mitigations. So in closing, sir, the panel acknowledges that key steps have been taken by the government to implement the recommendations in the CNAG's mid-term reflections, and that whilst not all of these recommendations have been accepted or implemented by government, they represent an important step forward for the CNAG and the Jersey Audit Office. And the panel is assured that the draft law is supported by both the CNAG and the PAC. As I've said before, sir, the panel welcomes the inclusion of the regulation-making power within the draft and as an additional step to empower a future assembly. So whilst the panel has considered the stakeholder feedback provided to the CNAG during her consultations on the proposal, we are assured that sufficient mitigations highlighted will account for and address stakeholder concerns about the proposals. Thank you, sir.
Thank you, Deputy. Does anyone else speak on the principles of this draft law? Deputy Gardner.
Thank you, sir. I would like to speak in support of the proposed amendments to CNAG law, and I do so warmly. As a chair of the Public Accounts Committee and as a committee, we work closely with CNAG, and as a chair, I play a direct role in the appointments for CNAG role, post and board of members. Public audit is one of the most important mechanisms we have to ensure that public money is spent properly, efficiently and transparently. The Controller and Auditor General, as mentioned in previous speeches, plays a crucial role in that system. This is not a proposition that has arrived from nowhere. As we heard, it was almost 2 years process that we have numerous conversations between myself and the Chief Minister discussing how the recommendations can be addressed. From the Public Accounts Committee perspective, we thought that it would be helpful to accept all recommendations, but definitely I understand the concerns raised by the government, and I believe this is a really good way forward, even if it's not perfect. As mentioned, the midterm reflection that was published by Synergy very clearly stated what is working in practice, but it needs to be sealed in the law. Interestingly enough, in November, we hosted here a Public Accounts Committee and auditors from the region, from a British Mediterranean region. And when we had the discussions about the powers and what's in the law, what's outside of the law, interestingly enough, the CNEJ law of Isle of Man was much more progressed than ours, even though that it was developed obviously much later. So definitely post-legislative scrutiny on any legislation is important. We are updating law after 12 years, and I hope we can continue to look what will be the good practice. So the question before us, if it's not reform needed, it's if it moves us meaningfully into the right direction, and I believe it does. Importantly, committee understands that a proposal can be implemented within existing resources, as the Chair of the Corporate Services mentioned, with no additional cost anticipated at this stage. And I would like to bring to the Assembly attention that over the last 2 years, when the budget proposal was debated, we did have a conversation with the CNEG, and the office and Board of Governors always found a way to ensure that the budget remains and not increased, and the necessary work is introduced. The office was very, very helpful. We found efficiencies in the managing the budget that was allocated. Public audit matters, and it's really a mechanism that Assembly holds executive to account on behalf of taxpayers. And for all of us, I think, the CNG work, her reports, her latest 2 reports, her value for money reviews, her recommendations only show how the work that office produce independently, it needs to be properly resourced and very transparently governed. So this proposal does strengthen it, and it's not perfect. None of the legislation is perfect, but it's really, really strong and good way forward. And this is why I'm pleased to support current proposition, and I ask members to do the same. Thank you.
Thank you, Deputy. Deputy Scott.
Thank you, sir. I have been a lay member of the Public Accounts Committee, and very much appreciate the work that is done by the Controller and Auditor General in terms of ensuring good governance and value for money within the organisation. I'm also aware that there has been this change, or at least from an initial proposal, that the Controller and Auditor General could act as a corporation. So it is incredibly important, and I'm aware there's a lot of conversation about whether arm's length organisations exist and that they've become runaway trains. I'm always going to remind members that ultimately the CEO is the principal accountable officer for all these, and the Treasury has a role in controlling their expenses too. But I nevertheless remain happy that there is a board of governance that remains in place, and I believe that, and as I will be saying in my unpublished report for the Public Ombudsman, that in fact I believe that this board of governance could perhaps play a dual role in terms of the governance of any future public ombudsman. Thank you, sir.
Thank you, Deputy. Does anyone else wish to speak on the principles? Chief Minister.
Thank you, sir. Can I thank members for the members who spoke and reiterate my thanks to the Corporate Services Panel and the PAC for working with government to achieve this position, which is a marked improvement on where we were. I have already highlighted the key features of the draft law, sir, but I would be pleased to field any questions should members have them in summing up, sir, and I would like to propose the articles en bloc. Thank you.
Well, we're doing the principles at the moment, but we'll get to the articles
Sorry, I
soon.
beg your pardon, sir. Yes.
You asked the appel, or should we just have a standing vote?
Sure, please.
Appel has been called for. Members are invited to return to their seats. I ask the greffier to open the voting. If all members have had the opportunity of casting their votes, I ask the greffier to close the voting. I can announce the principles adopted unanimously, 41 votes for. Deputy Miles, do you want to confirm that your panel wishes to scrutinise the matter no further?
Thank you, sir.
Thank you very much. Chief Minister, how do you propose the articles in second reading?
Thank you, sir. May I now propose them en bloc, please?
Thank you. Are the articles seconded?
Yes, sir.
Does anyone wish to speak on the articles in second reading? Those in favour kindly show. Thank you very much. The articles are adopted in second reading. Chief Minister, do you propose the matter in third reading?
I do, sir. I am grateful to members for their consideration and support, sir. I commend the draft law to the Assembly in the third reading. Thank you.
Thank you very much. Is the matter seconded in third reading?
Yes, sir.
Does anyone wish to speak on the articles as adopted in second reading in third reading? Those in favour of adopting the articles in third reading kindly show. The appel has been called for. Members are invited to return to their seats. I ask the greffier to open the voting. If all members have had the opportunity of casting their votes, I ask the greffier to close the voting. I can announce that the draft law has been adopted unanimously in third reading, 43 votes for. The next item is Bailiffs Consultative Panel, amendment to terms of office lodged by the Privileges and Procedures Committee. I ask the greffier to read the proposition.
The States are asked to decide whether they are of opinion to refer to the Acts dated the 7th of July 1992, the 4th of February 2003 and the 16th of May 2006, in which they agreed to establish a consultative panel of elected members of the States with whom the bailiff would be able to meet in order to consult on a confidential basis in appropriate cases and subsequently to amend the constitution of the panel, and to agree that, after the elections to the States Assembly on 7th of June 2026, A, those members elected to the panel by ballot shall be chosen at the same meeting as that at which, in accordance with Standing Order 112, the members of scrutiny panels are chosen, and B, the term of office for members elected to the panel by ballot shall align with the election cycle.
Chair of PPC.
Thank you, sir. This proposition would make a minor change to the term of office for members of the Bailiffs Consultative Panel. As members are aware, this is a panel with which the bailiff consults on matters such as Liberation Day. There are some members who sit on the panel by virtue of their office. Myself, as chair of PPC, the Chief Minister, the Treasury Minister and the chair of the Committee. But there are also 5 other members who are selected by the Assembly through a secret ballot. Members will recall this taking place on our first meeting in January of this year. The constitution of the Assembly was agreed through the adoption of various propositions. As things stand, the term of office for those 5 members who are selected is 3 years. This does not align with the current election cycle of 4 years, something which this proposition aims to address. Having a 3-year term when the election cycle is 4 years raises the possibility of appointments being missed and the panel being inchoate. Indeed, that has happened. It requires a decision of the Assembly through the adoption of a proposition to change the term of office. PPC has no responsibility for the Bailiffs Consultative Panel, but the committee agreed to lodge the proposition in order that the Assembly can take a decision. Someone has to lodge it, and it is PPC who has brought such propositions in the past under ministerial government. If adopted, the selection of the 5 members would take place alongside all other appointments after the next election. Reference is made in the proposition to the meeting at which scrutiny panel members are selected, but that is also the meeting where members are appointed to other bodies, including PPC. It is therefore an appropriate time for members of the Bailiffs' Consultative Panel to be chosen as well. The wording of the proposition means that the term of office on the panel would mirror the election cycle, if any change to the election cycle were made in the future. Sir, I make the proposition.
Thank you, Chair. Is the proposition seconded? Thank you. Does anyone wish to speak on the proposition? Those in favour of adopting the proposition kindly show.
For the appel.
The appel has been called for. Members are invited to return to their seats. I ask the greffier to open the voting. If all members have had the chance to cast their votes, I ask the greffier to close the voting. The proposition has been adopted unanimously, 42 votes for. Next item on the order paper has been deferred. And the next item after that is the draft Health and Social Care Professionals Register Law, lodged by the Minister for Health and Social Services. The main respondent is the Chair of the Health and Social Security Scrutiny Panel. I ask the greffier to read the citation.
Draft Health and Social Care Professionals Register, Jersey Law 2000, a law to provide for the registration in Jersey of health and social care professionals and specialist healthcare services. The states, subject to the sanction of His Most Excellent Majesty and Council, have adopted the following law.
Minister.
Sir, if accepted, this draft law would standardise professional registration in Jersey by creating a single, consistent system of secondary local registration linked to the UK regulatory bodies. It will improve oversight, public protection and the accuracy of the island's professional register. It follows our long-standing policy, which has been to anchor our system to the UK statutory regulators, bodies such as the General Medical Council and the Nursing and Midwifery Council. Given our small scale, it's obvious that running our own system of regulation would be incredibly expensive and far less robust than that of a large jurisdiction. But what the draft law will do is allow the JCC to maintain an up-to-date and comprehensive register here in Jersey of every professional practicing in the island. In short, sir, the purpose of the local register is threefold. Firstly, it improves assurance for islanders. It also protects islanders from risk and harm. And finally, it gives us a clear oversight of who's practicing. The new draft law is necessary because the current registration system is both fragmented and outdated. At the moment, sir, 5 separate laws govern healthcare registration in Jersey, resulting in inconsistent registration requirements across many different professions. Some healthcare professionals have to pay fees and renew their registration every year, while others do not. This is unfair, and there's no logical reason for it. Some professionals still register with the Judicial Gref and the Chief Pharmacist, while others register with the Jersey Care Commission. This is both confusing and inefficient. As a result of these inconsistencies, we have no single accurate record of all regulated healthcare professionals practicing on the island today. As a consequence, we lack oversight of exactly who's practicing here, where they work, and what their qualifications are. This increases the risk that unfit practitioners could practice unnoticed in Jersey, particularly those who work for themselves. This, of course, is not reassuring for islanders who access services. The new law would repeal and replace the current piecemeal legislation with a single consolidated framework law, ensuring that registration processes in Jersey are both fair and consistent. It's also worth mentioning that the Commission will no longer have unilateral powers to cancel or suspend professional registrations as they do now. This should and would be left to the UK regulators that have the requisite expertise and processes to do this. But the Jersey Care Commission would finally have oversight of exactly who's practicing in Jersey, their employment status and the qualifications they hold. It would also align us with the UK as far as that's possible. And going forward, if any profession becomes registrable in the UK, it would also become registrable in Jersey. So before I conclude, I should add that following consultation, I thought it best to ensure that no registration fees would be charged to any registrants. This ensures fairness across the board in a registration environment where many registration payment inconsistencies have evolved over the course of time. If we were to continue with local charges, it would involve many professionals having to pay to register in both Jersey and the UK, and that's a pressure that the health service workers could well do without at this time, sir. Some additional funding will be required to cover the marginal costs of implementing the charges and to cover the loss of the fee income. Those costs are estimated at £70,000 annually, but it will be subject to further review during 2026. And so it was deemed sensible that this sum should be funded from the existing HCJ budget, being a relatively small price to pay in order to deliver uniformity and parity to all concerned. During the course of 2026, a communications plan and guidance will be produced to support registrants with the transition to the new registration regime, and it's anticipated that the work will have been done in time for the draft law to come into force on the 1st of January 2027. In conclusion, sir, the law is about promoting fairness and public safety. It doesn't reinvent the wheel, it simply creates a robust, coherent registration system in Jersey based on legislation and processes that are already in place. So I urge members to support the law. Thank you.
Thank you, Minister. Are the principles of the draft law seconded? Yes, sir. Thank you. Does anyone speak on the principles of the draft law? Deputy Coles.
Thank you, sir. Members will be aware that I have an amendment in the articles of this legislation, but I do want to stand up and support the principles because I think what the Minister has produced here is good to consolidate everything into a single law. It will also be removing some gaps where some professions didn't have to maintain a membership to a professional body where other people did. So people like chiropractors, psychologists and physiotherapists now have to maintain memberships to professional bodies where previously they didn't. So yeah, I think I just want to say well done to the Minister for bringing in this these regulations, this law, because I think this will tidy things up and make things a lot more fair and balanced to professionals around the island.
Thank you, Deputy. Deputy Luce.
Thank you, sir. Sir, I speak in this debate as the Minister with responsibility for the Health and Social Care Service Regulation Policy and the work of the Jersey Care Commission. This law fixes a long-standing problem. Jersey's registration system, as the Minister has said, is fragmented, outdated and inconsistent. The draft law will streamline administrative processes for the Care Commission and thus reduce costs overall. Today, professionals register under 5 different laws. Some register with the Judicial Grefg and the Chief Pharmacist. Some aren't required to renew their registration. Therefore, there's no single record or oversight of who is practicing here, particularly in the private sector. This law closes that gap and puts public safety first. I'm assured by the fact that the new framework creates one consolidated registration system, aligning Jersey with UK statutory regulators. It streamlines the process and reduces litigation risk for the Jersey Care Commission, whose role becomes clearer and more manageable under this law. The Health Minister has also listened to feedback and determined that no fees will be charged, while the costs of the changes will be sourced from existing budgets within the HCJ. For islanders, the benefits are immediate. A single public register showing exactly who is qualified, fit to practice and properly regulated. This assures islanders and strengthens trust in our invaluable healthcare system. Sir, this is a modern, fair, proportionate approach to registration that both protects the public and supports professionals working in Jersey. I support this law and urge members to do the same. Thank you, sir.
Thank you, Deputy. Deputy Dublé.
Thank you, sir. My panel have scrutinised this piece of legislation and in brief we are supportive of it with a slight reservation which I will come on to. And we welcome the legislation because at the moment the registration laws are quite fragmented. There are, I think, 5 separate registration laws. There can be some confusion sometimes with those different legislations and this alignment with the UK qualification and fitness to practice standards is a good thing. And having a digital register would improve transparency and accessibility for islanders. We did, however, we consulted with the Jersey Care Commission, and we have some concerns around this expanded regulatory workload and whether it is going to be adequately resourced in terms of staffing and digital capability. So it would be helpful if the Minister could comment on that in his summing up and provide reassurances that the Care Commission will be adequately resourced in order to implement this legislation, and that any other resources needed for the law to be properly implemented will be made available. But in summary, my panel are supportive of the principle of this legislation.
Thank you, Deputy. Does anyone else speak on the principles of the draft law? I call upon the Minister to reply. Minister.
So nothing to add other than I can offer Deputy Dublé assurance that the JCC are properly resourced, and that refers to the £70,000 that's going to be transferred that I mentioned.
Thank you. Those in favour of adopting the principles kindly show. The appel has been called for. Members are invited to return to their seats. I'll ask the greffier to open the voting. Four members have had the opportunity of casting their votes. I ask the greffier to close the voting. The principle has been adopted. 38 votes for and 1 abstention. Yes.
Deputy Wilson abstained.
Deputy Dublé, can you confirm that your panel have scrutinised this matter?
We don't wish to call this in, sir. Thank you.
Thank you very much. Minister, how do you propose the matter in second reading?
Take them all blocks, if I may.
Thank you very much. There's an amendment from Deputy Coles. Do you accept the amendment?
Unfortunately not, sir, for reasons which I'll explain during the debate.
Thank you. Are the articles seconded? Thank you. We now come to the amendment of Deputy Coles, which is extensive, and if members are content, I won't ask the greffier to read it all out. Members are content. Thank you very much. Deputy Coles.
Thank you, sir. Before I begin, I must declare an interest on the third part of my amendment, which concerns psychotherapists and counsellors, which is a profession in which my wife works and is recorded on my declaration on the States Assembly website. For clarity, I intend to take this amendment in 3 parts. First part, removing the unnecessary UK-centric drafting. 2, inserting the PSA accreditation voluntary register into Schedule 1. And 3, reinstating psychotherapists and also including counselling-related professions within the register. These 3...
Well, at some stage, you tell us which articles are affected by those first, second and third things accordingly.
So, sir, that is paragraph 9. It's all articles in the amendment, other than the ones listed in paragraph 9 of my amendments, are the UK-centric.
So that's your amendments 1 to 8 inclusive, yes?
Yes, and then 10 and onwards as part of that as well, sir. Paragraph 9 deals with the Schedule 1, which is interpretations, and then items on the list of the schedule, sir.
So could you just repeat that? So your amendments 1 to 8 are the UK issue, yes?
Sorry, bear with me 1 second.
Just so we know exactly where we are.
Can I borrow?
You're proposing in...
So, yeah, Article 1 to 8, and then 9 is the schedule, and there's part 1 and 2 in that, but then there's paragraph 10, 11, 12, 13... Yeah, and 13 on on the amendment page, sir.
And that's the third amendment, the third
No,
part.
that's the first amendment.
Right.
And then paragraph 9 in the amendment breaks down into two parts. There's a paragraph 1, which
Yes.
is the interpretations.
Yes.
And then there is the second paragraph of paragraph 9, which is the list of professions on Schedule 1, sir.
I see. So it's everything apart from your 9th amendment, and that's dealt with in two parts.
Yes, sir.
Thank you very much. Thank you.
So I hope that is now clear as mud for all members concerned. And if we go through it again, we will do, sir. So, sir, these three elements work together to strengthen the law, modernise it, and ensure that it reflects Jersey's constitutional position and practical needs. So let me be absolutely clear from the outset, this amendment does not lower standards, does not remove safeguards, and does not prevent cooperation with UK regulators. What it does is future-proof legislation, preserves Jersey's autonomy, and ensures a proportionate regulation for professionals already practising in our island. As I've just explained, sir, it is my intention to take this in the three parts as just explained, and we won't go back through that if members require it. It is also, sorry, I've lost track on mine. Just to be clear, on the third vote, sir, just to add to the extra confusion, that these are a lot of individual professions to be introduced into the schedule, and if members wish, I can take those line by line, and so if there is professionals within there that members want to be included but don't, please indicate that to me, and I will take it as a single vote line by line, and apologies for the extra delay that will cause to today. Sir, the Minister's comments papers suggest that removing references to the United Kingdom would weaken alignment with the UK regulatory bodies and create uncertainty. That is not the case. The amendment removes the requirement to rely exclusively on UK registration. It does not prohibit reliance on the UK regulators. The Minister retains full power to use UK standards, UK bodies, and UK qualifications. Nothing in this amendment prevents that. What it does is remove the structural requirement that Jersey's regulatory framework must forever mirror whatever Westminster decides. We are a self-governing jurisdiction. Embedding the UK throughout primary legislation unnecessarily ties our system to another legislature's future decisions which we have no influence over. If the UK changes its regulatory structures, and they do, Jersey should not need to amend its own primary legislation to simply maintain its functionality. This amendment increases flexibility. It does not reduce protection. The Minister's response appears to treat the UK as the only credible benchmark. I do not share this view. Healthcare standards are not exclusively preserved of one country. Highly regulated professions exist in Europe, Australia, New Zealand, North America, and elsewhere. Jersey already recognises qualifications from multiple jurisdictions in other contexts. We operate equivalency-based recognition systems in law, financial services, and teaching. By removing the hard-coded reference to the United Kingdom, we will allow future ministers and future assemblies to consider other high-standard regulatory systems if they are in the interest of Jersey. That is the power of choice and not the rejection of the UK. If the UK remains the gold standard, it will continue to be used, but legislation should not unnecessarily restrict future policy discretion. The Minister suggests that recognising the PSA accredited voluntary registered, that's the Professional Standards Authority, would be misleading, would mislead the public or equate voluntary regulation with statutory regulation. I believe this misunderstands the role of the PSA. The PSA is the regulator of regulators. The PSA accreditation is not casual. It involves independent assessment of governance, complaints procedures, and standard settings, and a public protection mechanism on top of this. These registers are already recognised across the British Isles as providing a proportionate oversight for professionals not subject to statutory regulation. The amendment simply allows that these accredited registers to form the basis of recognition in Jersey and on the Health and Social Care Professionals Register. Psychotherapists, professionals already practicing in Jersey, all of them are currently regulated by the Care Commission, use the PSA accredited bodies to validate their qualifications and maintain their standards. The current drafting not only excludes them, but removes them from current oversights. My amendment restores them into this structure in a standards-based way. This is not overburden, this is proportionate inclusion. Sir, the Minister raises three broad objections: inconsistency, public safety risk, and regulatory burden. Each is misplaced. Inconsistency. The Minister warns of a patchwork of regulators, but the amendment does not require the Minister to accept any regulator. It simply allows the Minister to do so where appropriate. The Minister already has powers under the law, the draft law, and it will be up to the Minister of the day to decide how those powers are used. It will be up to the Assembly of the day to challenge those orders should they stray too far. For public safety, the amendment does not remove the requirement for registration. It does not remove offences, it does not remove renewal, it does not remove conditions or suspension powers, it does not weaken enforcement. It simply adjusts the gateway criteria so that Jersey law does not unnecessarily embed another country's legislative framework as the only qualifying standard. In fact, it adds to public safety by requiring the maintenance of standards and that this draft law seeks to remove in the terms of psychotherapists. It adds to public safety by requiring additional professionals to maintain their standards and add a level of accountability. Regulatory burden. The Minister warns that regulating psychotherapists could deter practitioners, but the amendment uses the PSA accredited bodies, the very bodies that many Jersey practitioners already belong to. This is not new regulation, it is continuity. Sir, primary legislation should express Jersey's authority, not outsource it. We cooperate with the UK, we align with the UK, but we are not administratively subordinate to it. This amendment ensures that our law reflects that constitutional reality. So in closing, sir, this amendment strengthens flexibility, preserves public protection, recognises legitimate accredited professional registers, and future-proofs the law. It does not seek to weaken the framework, it refines it. And for those reasons, sir, I make this amendment.
Thank you, Deputy. Is amendment seconded?
Yes.
Thank you. Does anyone wish to speak on the amendment? Deputy Barnable Ward.
Thank you, sir. I wasn't actually going to speak on this, but just listening, I'm actually feeling very uncomfortable about the amendment that's been put in, and I'm really thinking I should express my objection. The UK governing bodies, they provide due diligence. As our registering bodies, it's for doctors, nurses, dentists. It is a huge range of governing bodies. It provides the confidence. The governing bodies are there to do investigations on complaints of professionals. They are large organisations serving a large population with their lawyers, etc. They make decisions on professionals, on their standards. They are the standard setting, and they maintain the confidence and the protection on behalf of patients. For Jersey to ignore our UK governing bodies, in my view, is foolhardy. It's unsafe, and quite honestly, it's totally unaffordable. For Jersey to actually take on the role that our governing bodies do, we talk about trying to keep Jersey in line with £1 billion. To actually take on all the registering and all the work that they do would probably wipe out our income. I think we need to be really sensible. Jersey's equivalent to a small town. There is no town in the UK that would be wanting to do what is being proposed in this amendment. We have very safe governing registering bodies that look after our professions that we totally rely on for our health care and welfare from the cradle to the grave. We must have that litmus test. We must have that consistency with our governing bodies. I know that there's other governing bodies in America and whatever, but they have to come through one litmus test, and that is our governing bodies in the UK, where it's enshrined in law. Let's keep it that way, sir. Thank you.
Sorry, sir, can I ask a point of clarification?
Prepared to give way? Point of clarification?
Yes, sir.
Yes.
Thank you, sir. The member, I think, mentions that Jersey would be setting its own regulators up. I just wonder where she could point to in my amendment that I'm suggesting that we are setting up our own regulators and not using the PSA, which is a governing body of the UK already.
Just to give a bit of history, it was with the thanks of the Solicitor General back in the 80s, Sir Philip Banash, that I went to see about setting up, about having the word nurse protected in law. The easiest way would have been to have it on the United Kingdom Central Council, which was our nurses governing body at the time. All you had to do was put, and the Channel Islands, so that would give us the protection of everything else. Anyway, that didn't happen, sir. And then it changed to the NMC, and they still didn't do it. Hence, we set up our healthcare registration body, and that's where it started. So you can thank me and Sir Philip for that, and with the Public Health Committee at that time, and dear Sir Peter Lambert. And that has evolved over time. And what happens is, I mean, a computer was set up, I'm a nurse, and I have to put in every year to the governing body here in Jersey and register every year at no cost. The computer's already there to cover the biggest group, which is the nurses. The next one in line is the GPs and the doctors and then the dentists, who still are responsible to our governing body. But we do register, so there is a computer list of those professionals already as we speak. I usually have the piece of paper that shows that I was registered as of last year until December this year. So that's how it actually stands, sir.
Thank you. Deputy Luce.
Thank you, sir, and I rise again in my capacity as Minister responsible for the Jersey Care Commission. While I appreciate the intention absolutely behind Deputy Cole's amendment, I'm afraid I'm unable to support it, as it would place responsibilities on the Care Commission that is not currently structured or resourced to fulfil. Adopting this amendment could create pressures that may unintentionally divert the Commission from its core role as a service regulator and lead to additional administrative and financial burdens. Although I fully recognise the Deputy's commitment to public safety, the amendment introduces expectations that the Care Commission cannot realistically meet under its existing framework, and I'll outline the reasons for this, sir. The Care Commission is not a regulator of professional services. It provides a secondary registration system for professionals only. This amendment treats the Commission as if it were a professional regulatory body akin to the General Medical Council or the Nursing and Midwifery Council. Those bodies operate at scale, nationally across the UK, with large specialist teams, with statutory fitness to practice panels, detailed codes of professional conduct, and legal infrastructure to investigate, sanction, and strike off professionals. By contrast, the Care Commission is a service regulator comparable to the UK Care Quality Commission, which inspects services, not individual professionals. That's what it was set up to do under the regulation of care law. Expecting it to undertake full professional regulation would represent a fundamental expansion of its remit, requiring significant new resources and structural changes. Regulating psychotherapists, counsellors or other practitioners proposed will, in fact, have significant cost. To regulate health and social care professionals meaningfully, the Commission would require proper professional regulatory infrastructure and specialist expertise with a significant increase in funding to cover those costs. The reason our long-standing policy in this area relies on the UK to do this work for us is that it costs a huge amount and exposes the taxpayer to great risks. To have effective local professional regulation, we would need the following that we don't currently have. First, the new regulatory infrastructure we would need to invest in to regulate these counselling professionals effectively includes codes of conduct and professional standards for each profession, clearly defined fitness to practice criteria, evidence-based assessment processes, and a legal framework establishing powers and thresholds for sanctions. Amongst other things, sir, that would also require the Health Minister to come back with further changes to this law to enable the Commission to regulate these professionals effectively in Jersey. That's more policy and legislative drafting time to pay for. This would all be bespoke and unique to Jersey because we would be the only place across the British Isles to do this. Secondly, we would need to invest in new specialist expertise for the Commission, including panels of professional peers, clinical and practice experts, legal advisors, and investigators trained in regulatory casework. There are no existing staff on island capable of performing these functions at a regulatory standard for psychotherapists and counsellors. Expertise would have to be imported, contracted, or newly recruited. The establishment and operation costs would likely run into hundreds of thousands of pounds per year, but clearly there's no funding attached to the amendment. Without funding, this exposes the Commission and ultimately the Jersey taxpayer to significant litigation risks. This is because complaints from the public would likely go unaddressed, fitness to practice processes could be easily challenged, and the Commission would face legal liabilities for inadequate or flawed regulatory action. I also note the suggestion that accreditation bodies could carry out these functions. Last year, in response to the Deputy's proposition on the same subject, officers considered this and approached organisations including the British Association for Counselling and Psychotherapy to ask if they would even be willing to act as a regulator for Jersey's counsellors. They said no. Accrediting bodies are not regulators. They have no statutory powers. They cannot strike off practitioners for practicing in Jersey. They provide membership frameworks, not public protection. I emphasise government has already explored this option and they cannot undertake the responsibilities proposed. Therefore, if the Care Commission does not receive funding to do this work itself, meaningful regulation simply will not exist. If the amendment were adopted without the necessary infrastructure, the public would, nevertheless, expect the Commission to take action on concerns about counsellors. However, without the appropriate powers or resources, the Commission would be unable to meet those expectations, which could undermine confidence in the regulator. Even if substantial new investment were made available, members may wish to reflect on whether this is proportionate given the wide range of health and care priorities facing Jersey. Without significant funding, the proposal is, I'm afraid, unworkable. Equally, I don't think that resourcing this would be proportionate. Sir, while I absolutely fully respect the intention behind the amendment, it introduces significant practical, legal, and financial challenges that the current system is not equipped to manage. For these reasons, I cannot support the amendment and encourage members to reject it. Thank you, sir.
Thank you, Deputy. Minister.
Sir, with apologies for trying members' patience, they may have to put up with me covering a few points that have already been covered by Deputy Ward. and Deputy Luce, but I think such are the implications of accepting this amendment that I think it's right and proper that I go through the points of detail as coherently as I can, because there are real risks here. So, sir, at the heart of this draft law is a single fundamental objective: to strengthen public protection by creating a clear, consistent and legally robust system regulating health and social care professionals in Jersey. Deputy Cole's amendment would, I regret to say, undermine that objective for 3 reasons. Firstly, it weakens the foundations of our regulatory system. Secondly, it would grant sweeping new powers to the Health Minister on matters that should be decided by this Assembly. And finally, proposing to include psychotherapists is premature, unsafe, and it creates barriers to employment that exist nowhere else in the British Isles. So I'll address each of those points in turn. It weakens the foundations of our regulatory system because Jersey relies heavily on the UK workforce. Aligning with the UK is therefore logical, reliable, and ensures that islanders receive care from practitioners meeting clear and proven standards. However, Deputy Cole's amendment would break that link. It proposes that any regulator anywhere in the world, including non-statutory bodies, could become the basis for Jersey registration. That would introduce inconsistency, uncertainty, and legal risk to our system. These are matters that cannot and must not be ignored. Public protection can't be left to rely on a patchwork of global standard with no assurance or equivalence. My second point, the inappropriate increase in ministerial power, is related to the first, but is concerned with the constitutional probity of what Deputy Coles proposes. Because, as I've outlined, allowing healthcare professionals who are not regulated by the UK regulator to register in Jersey would have such significant implications and alter decades of consistent policy, it must be taken on a case-by-case basis by the States Assembly. This amendment, however, would grant the Minister very broad powers to accept primary registration from any regulatory authority anywhere in the world, or even from non-statutory bodies accredited by the UK Professional Standards Authority without reference to the States Assembly. To emphasise, if a minister exercised these powers, this could mean that 2 clinicians working side by side in Jersey could be subject to entirely different rules and levels of oversight. That level of inconsistency would weaken professional governance, undermine public confidence, and risk Jersey's reputation, having moved away from the healthcare system previously aligned with the UK's strong regulatory framework. If Jersey ever wishes to diverge from the UK regulation, that is a major policy decision and one that should be debated openly and approved by this Assembly, not made unilaterally by ministerial order. For these reasons, it's clear that the Minister's powers should remain limited to including UK regulators only. Finally, Deputy Coles also proposes adding psychotherapists and an array of related titles, such as counsellors, play therapists and talking therapists, immediately into Schedule 1. So I think members need to be clear on this matter. The proposition would only increase the risk to public safety because it would lead the public to believe that these professionals will be regulated when, in fact, this regulation is entirely meaningless and ineffective. This is not a rejection of the importance of psychotherapy or counselling, far from it. But these professions are not currently subject to statutory regulation in the UK, and the UK government has been explicit that this area requires further consideration before regulation is introduced. Counsellors may be accredited to a body, but those organisations are not regulators and could not be expected to act as such. In fact, the government has already approached accrediting bodies for counsellors, including the British Association for Counselling and Psychotherapy, to ask if they would be willing to regulate in Jersey, and they are not. Therefore, the only way for us to regulate counsellors effectively would be to provide hundreds of thousands of pounds in funding to the Jersey Care Commission to run the system locally. If this amendment is adopted, Jersey would be attempting to regulate professionals that have no established statutory framework elsewhere, have no recognised or aligned set of protected standards, and have no statutory fitness to practice system in the UK with which we can safely align. It would also require significant further law changes to provide the Care Commission with the powers and the remit to act as a primary regulator for their professional practices. Those have not been provided for under this amendment, so I'm afraid it would be unworkable, sir. As I've stated already, to implement effective local regulation would be hugely expensive and far less robust than relying on the UK statutory system, as we have done for decades. So it's for this same reason that the Assembly rejected Deputy Cole's proposition to regulate therapeutic counsellors in P21-2025 last year. In conclusion, sir, this amendment does not strengthen the draft law. It actually weakens it. It doesn't enhance public protection. It exposes the public to risk. And it doesn't improve our regulatory framework. It creates uncertainty and inconsistency at the very moment we are trying to bring uniformity, clarity, and coherence. And for those reasons, sir, I seriously urge members to reject this amendment. Thank you.
Thank you, Minister. Does anyone else wish to speak on this amendment? Deputy Scott.
Could I please ask the Attorney-General a quick question?
Yes.
I just want to understand the definition of a regulatory body and whether, if you've got a body that accredits people and it withdraws that, whether that could be interpreted as a regulatory function.
Is that a question you can answer, Mr. Attorney?
Well, the Care Commission doesn't regulate individuals, it regulates services. It would be in doing that, but if, let's say for the sake of argument it did regulate individuals, it would be doing so in a public law sense. Its decisions may be susceptible to judicial review in the same way that I think the General Medical Council's decisions are. But the Care Commission, as presently formed, as I think Deputy Luce said, simply regulates overall services.
Thank you. Deputy Tadia.
Sir, I want to start by referencing an oral question that Deputy Coles asked the Minister on the 3rd of February this year. He asked the Minister, will he outline his reasoning for omitting psychotherapists from Schedule 1 of the draft law? And the Minister said, he said, what was the reason for omitting that? The introduction of the new law was only ever intended to include those professions that are subject to statutory regulation in the UK. Psychotherapists are not regulated by the Healthcare Professional Council, and there is no statutory national standard qualification or fitness to practice requirements to which they could be aligned or against which they could be held to account. Local registration would not enhance public protection, and to insist on it would create unnecessary red tape with no meaningful benefit to anyone. That said, should the UK introduce statutory regulation for psychotherapists in the future, the new law has been designed to allow them to be added very quickly and easily. So what we're seeing here is effectively a circular argument being put forward by the Minister. So on the one hand, he says that we must always align ourselves to UK here. And I think this speaks to the first part of what Deputy Coles is asking for. Deputy Coles isn't saying that the UK shouldn't be used as the standard model to which this current health minister or future health minister should align Jersey's system. What he's saying is that if it happens, if the UK is the gold standard, that's fine. But if it happens in the future that the UK system becomes the silver standard, or should we say even the bronze standard, any future minister should be able to say, actually, there's a system in place in France, in Sweden, in Canada, in New Zealand, in Australia, because of course there are other countries in the world other than the United Kingdom which sometimes do things better, if we can imagine such a thing. And if they were to have a model which was in the future better, the law would be drafted in such a way that would allow that flexibility for change. And even if it wasn't the case that the UK had slipped in its gold standard, it might be that another country like Australia, like New Zealand, might have a platinum standard of healthcare regulation, which could be extended to psychotherapists. And so we get this strange argument being put forward again, which refers to that circularity, is that we don't include psychotherapists in this list, because the UK doesn't. But if the UK somehow decides automatically, without any consultation with us, that they are going to include that, then we will automatically include that as well. I don't think that washes, and I don't think it's a reasonable explanation. And to say that actually islanders would be somehow less safe if psychotherapists weren't included in that requirement to sign up, that they would feel less safe, because surely they couldn't be less safe. I think this would allow for a recognition that, and I thank Deputy Coles for providing the appendix that he did with some very useful supplementary information in this regard, that it is very serious that if people are going to psychotherapists who purport to be providing counselling services, advice, whatever kind of therapy it is, that they should be subject to scrutiny and to those professional standards, sir, and their associations. And I think that does provide a framework for doing that, sir. So I will simply refer back to what Deputy Coles says in his conclusion. So we know exactly what we're voting on. This would remove unnecessary references to the United Kingdom to modernise this legislation and reinforce Jersey's autonomy, whilst preserving the Minister's ability to draw on the UK or other international standards where this is in the best interests of islanders. It future-proofs the law and avoids the need for repeated primary legislative change as regulatory practice evolves. How many times have we heard in this Assembly that we shouldn't be slavishly following automatically what the UK is doing? And actually, it's absolutely right that the minister, I think we're being presented with a false dichotomy here by ministers when they say this would divorce us from the UK in terms of the health practice system. It doesn't do that at all. It simply allows for this to be future-proofed so that if in the future the UK isn't moving fast enough, it doesn't include those extra areas that need regulation, and it does somehow fall, because of course we don't have control over UK budgets. Tomorrow, next year, the UK Chancellor of the Exchequer could decide that they're going to cut certain areas of the legislative programme or of the budget that funds healthcare, and we could see that we're being linked, if you like, in an unwilling three-legged race with the UK, when actually what we want to have is the ability to say, you know what, I'm going to uncouple myself from this, and we're going to, in future, if we need to, couple ourselves with other healthcare regimes which might suit us better. So I reject that false dichotomy. I commend Deputy Coles for what he's put forward here, and certainly for my part, I'll be supporting the amendment.
Thank you, Deputy. Deputy Moore.
Thank you, sir. It does appear that there are merits on both sides of the arguments here. Whilst I absolutely respect the Minister's proposal to bring clarity and structure to what is an extremely important part of delivering health services, I also have some great sympathy for Deputy Coles' argument, and I find it, I'm afraid, disappointing that the Minister is so focused on taking one track and not taking time to investigate how we could in fact deliver a better health service by looking to other nations and other practices. Those can offer different avenues of delivery and providing oversight to professionals that could actually assist in getting the budget under control, which of course, as we're all aware, he seems incapable of achieving. If I could provide one simple example, I'm aware that in France, nurses, senior nurses, are also able to administer anaesthetics. I'm aware that there was one such nurse who tried to seek a job in Jersey some years ago, and it took an incredible amount of time to actually find a role for that nurse, and they were unable to deliver the very services that they were highly trained in delivering because of the rigidity of our structure. And so if we had been more open to seeking better practice from other places, there would have been a better, a more cost-effective approach and solution for our health service. So I'm afraid, sir, I find this very difficult because clearly there are some technical issues with Deputy Coles' amendment. However, I am deeply disappointed by the approach of our Minister.
Thank you, Deputy. Deputy Howell.
Thank you, sir, and I thank Deputy Moore for her comments. I would like to say there are advanced nurse practitioners in our health service who are stepping up to be at the top of their game. And I would also like to say that Deputy Tadier seems to have ignored the important things that the Minister has said. Thank you, sir.
Thank you, Deputy. Does anyone else wish to speak on the principles of, on this amendment? No? Yes, Deputy Scott, yes.
Yeah, I also sympathise with Deputy Coles. I do worry a lot about people practising poor psychotherapeutical practices in Jersey. And I just think it's unfortunate because had this amendment been drafted a bit differently, maybe I could have felt a bit differently about it, because I think there is a difference between accredited bodies and some are actually quite respected in the UK, as opposed to regulatory bodies which have a more precise meaning. But this is actually expanding the net to even outside the UK. So I think this merits thought, much further thought, but I'm not tempted at this point to support the amendment.
Thank you, Deputy. Does anyone else wish to speak on the amendment? If no one else wishes to speak, then I call upon Deputy Coles to reply. Deputy Coles.
Thank you, sir. I think there's been a lot of talk around different aspects of this, but not sort of pulling together where the differences in the parts lie. So maybe it'd be good if I go back a little bit to the beginning, in the sense that when this legislation was published, I was actually on holiday at the time, still reading my teams and looking for things as they're published, because they're the points where, you know, we, as politicians, we're always working. So that started me on the journey with the legislative drafters to try to push forward what I was trying to deliver with these amendments. Of course, my original objective was quite simple, that I wanted psychotherapists and counsellors to be regulated in Jersey, because it's one of those practices that needs to be kept an eye on. We have issues over here with people with their mental health, and people need to make sure when they are going to these professionals that they have a standard of qualification behind them. But of course, when you start that journey and you realise that actually to get that into the legislation, you have to make a series of other amendments. And this is where then the work really started with the drafters, to make sure that I wasn't going to compromise the legislation as it was drafted. But the main obstacle for getting psychotherapists and counsellors to be registered on this professional register was this intrinsic tie with the UK. So this is what I'm saying with the first part of this amendment, the first vote, is to remove that element of that rigid connection to the UK. I said in my opening speech, sir, that by removing that rigid UK-centric drafting to the legislation, this doesn't stop the minister still using UK regulatory bodies as the key centre of this. So that's why I think it is really, really important when we consider this amendment and removing the UK from the UK-centric part of this legislation, is what happens in an emergency situation. What happens if there's a scenario that we can't foresee, say another pandemic, where we're struggling for nurses, doctors, but we can recruit them from France, our closest neighbour, somewhere we can get a small boat across quite easily. But actually this would allow the minister to use the emergency power to recognise the French at that point to come in and actually work here. At the moment, that wouldn't be allowed. We'd have to come back, change legislation, and then work through that. But this is just one example. Obviously, Deputy Moore mentions the fact of a French nurse who could have been very well placed to help us over here. I'm also aware of a professional within our health service at the moment who is actually a lot more qualified, but just not in a body that we recognise. She meets the standards in one sense to become a GMC member, but not the standard to become a consultant in a particular field. And I think that's a shame, because this person is a very talented doctor, but this is where we are. So I'll reinforce the point for this, the first vote on this, is that it's just to remove the UK-centric part. Doesn't mean that we can't use the UK, doesn't mean that we're not we're putting extra burdens on anybody. It is literally just the UK-centric part removed. The legislation still reads this, works exactly the same way, and the Minister can provide standards. I'm slightly concerned of how the Minister perceives this as well, because he's talking about the order-making powers and the Assembly, but of course, under the law as drafted, the Minister has the order-making powers to put people into this register. So if the UK decides that if the UK decides that they are going to change the law and all of a sudden acupuncturists, for another example, have to be regulated, the Minister can straight away say, right, acupuncturists in Jersey have to be regulated. I'd happily support that, because there's another profession I do believe needs to be regulated when you're sticking needles into people. But it's not a decision of the Assembly, it's still a decision of the Minister. So the Minister already has the powers, and the law is drafted. The Assembly only has the power to annul, as Deputy Curtis mentioned yesterday. These powers are very specific for the Assembly and how the Minister does. So I don't want to confuse my second and third part of this amendment, which it was my original objective. Because actually, the problem with being UK-centric ruins our autonomy. Let's give us the right to flex our own individual needs when we need them, when we foresee them. This does, though, lead me on to my second part, which is about the PSA, the Professional Standards Authority. Now, the Professional Standards Authority was set up by the UK to provide oversight for the statutory regulators, people like the GMC, the Nursing and Midwifery Council, and a number, to make sure that those statutory regulators comply with the statutory regulation that they are meant to, under the UK law, deliver. So the Professional Standards Authority, under, I'm trying to remember which law it was now, this, an NHS Reform Act, opened up their accredited register, where they do still require the professional standards to be there, a public protection mechanism, so that actually when a member loses their membership or does something that breaches the terms and conditions of their membership, they can be removed. And of course, that is what happens with the GMC, Nursing Midwifery Council. They call it being struck off under statutory powers, but you can lose your membership under one of these accredited registers. And as this law works, they wouldn't be then allowed to practice in Jersey. See, both Deputy Ward and Deputy Luce were making out that this, as drafted, would make the Jersey Care Commission become the primary regulator. It's not. It's still that point of registering the service. And the professional under that would have to make sure they were a member of a body that complied and had the PSA accreditation to verify their qualifications and standards. In the same way that previously the chiropractors and physiotherapists didn't have to maintain their professional membership, and this law changes that so they do have to maintain that professional membership, it would put that responsibility onto psychotherapists, counsellors, and anybody else from this list to actually maintain their register. It is not making the Care Commission set up as a primary regulator. They're still not doing that, and there's a misnomer that it's incorrect information. And so it then begs the question, when I had the Minister behind saying this amendments would make this meaningless, but then the Minister for the Environment saying this would cost us millions. So which one is it? Is it meaningless or is it millions? Because I don't agree with either. I think it's proportionate and it's consistent with what's already there. It's creating the safeguarding, it's creating better public protection. And of course, it was mentioned about my previous attempt for regulating counsellors and psychotherapists. And I know one of those other questions that came up in that debate was whether or not our consumer protection laws did enough to protect people from bad practice with counsellors, because obviously psychotherapists, as it currently stands, are actually registered under the Care Commission. And so I seek now advice from trading standards, and the advice that came back from them was it's only retrospective. Someone would have to go to them and say, I had bad counselling service, I would like my money back, because that's all that trading standards can do. People have no recourse for bad practice when it comes under these unregulated services. And of course, we talk about public confidence and the Minister mentions it in his comments as well, that we know we have waiting times, especially in mental health, which are longer than any of us would like. And the reality of this, sir, is that it drives people to seek private services. And islanders deserve certainty with those services, sir. And so with counsellors and psychotherapists being maintained on this register, having to actually show what their qualifications are before they're allowed to set up in practice, and maintain those professional standards as the bodies that they can join as part of the Professional Standards Authority, gives the public that certainty and those standards and those protections. So, sir, I think that my amendments are appropriate, but for clarity, the first vote again will be to remove the UK-centric part, so Jersey can be flexible or it can maintain what it's already proposing. It doesn't have to change it. And I think that's a really important part for us to consider. Obviously, like I said, part 2 and part 3 of this are my personal agenda, and I'm not holding that back. But I think the first part is really important, so we can adapt in the future should we need to. And that's I will call for the appel on my amendments.
Thank you, Deputy. The appel has been called for. So the first vote is on parts 1 to 8 and 10 to 13, inclusive of the amendment, which remove references to the UK and United Kingdom from the legislation. I invite members to return to their seats now. Sir Greffio to open the voting on that part of the amendment. All members the opportunity of casting their votes. I ask the Greffier to close the voting. That's the first part of the vote has been rejected. 11 votes pour, 29 votes contra, and 3 abstentions. I'll move on to the second matter.
So I think then beyond that, the rest of it falls away, because without this then doesn't meet UK statutory provision without those bits being removed.
Understood. Thank you very much. The rest of the amendment falls away. So we return to the second reading. Does anyone else wish to speak in second reading in relation to the articles? Yes, Deputy Balash.
Sir, I did share some of the concerns of Deputy Coles, but I didn't speak because I thought that his amendment was effectively blown out of the water by the speeches of Deputy Barbara Ward and the Minister of the Environment. It was just impractical to do what the Deputy wanted us to do. But there are concerns about the law which I would like to share with the Assembly. In particular, I'm looking at Article 2 of the law, references to United Kingdom acts and subordinate legislation. What Article 2 says is that if this law or the regulations or an order made under the law refers to an act or subordinate legislation of the United Kingdom, then paragraph B, Article 6 of the legislation Jersey Law 2021 applies in relation to that act or subordinate legislation of the United Kingdom. And what Article 6 of the 2021 law says is that if any Jersey legislation repeals any Jersey legislation and reenacts any of its provisions, references in that other Jersey legislation to the provisions so repealed are construed as references as to the provisions so reenacted. And put in plain language, what that means is in relation to United Kingdom legislation that if the Opticians Act 1989 of the United Kingdom is reenacted by some other United Kingdom Act, then that reenacted United Kingdom Act applies automatically in Jersey. And that ought to give us some pause for thought, I think, because it may not be possible to do it in any other way. I'd be interested to know in due course whether the Attorney General has any thoughts on this front. But it is rather alarming, I think, that we should be subordinating ourselves to legislation of the United Kingdom in this way. And that leads on to the second thought, which is that in Article 3, we apply a definition of scheduled occupation as meaning an occupation listed in column 1 of Schedule 1. And if we go to Schedule 1, we see a whole list of scheduled occupations, far, far beyond all the scheduled all beyond the occupations which we at the moment have applied to Jersey under the existing laws relating to registered medical practitioners, opticians, and so on. And I just wonder whether, and this is a question for the Minister, not for anybody else, I wonder whether the Minister did give any consideration to the possibility of taking this step by step by applying the Health and Social Care Professionals Register law merely to those occupations which are subject to legislation in Jersey at the moment, taking it gradually without necessarily bringing in the whole host of scheduled occupations which are dealt with in the first schedule. And that in itself leads on to another point, which I think was considered by the Health Scrutiny Panel, which is the position of the Jersey Care Commission in relation to this legislation. Because my understanding, and I don't have the piece of the scrutiny panel in front of me at the moment, and I can't recall whether in fact we mentioned this in our report or not. But so, as I recall, the Care Commission was very concerned that it did not have the resources to deal with the wide range of scheduled occupations that are listed in the first schedule. And there seemed to be a dispute between the Minister and the Care Commission, in that the Minister was saying, well, Care Commission, you've got to deal with this under your existing resources. And the Care Commission was saying, we don't have the resources to deal with this regulation. And this is a matter which I hope the Minister will deal with in his reply as well.
Thank you, Deputy. Does anyone else wish to speak in second reading? Yes, Deputy Alex Curtis.
Thank you, sir. And my comments are going to be in a very short but different direction to many might expect. it could equally be in the first, second or third reading, but I'll reference Article 41 in particular. And note that I think the Articles Act ultimately propose a new consolidated register, one that sits in the Care Commission is very good. And Article 41 repeals a number of laws which would fall into this. And one that I want to highlight is the Opticians Registration 1962 law. Now, so you may know that Article 4 of the Opticians Law requires that register, now to be appealed, to be affixed to the lobby of the Royal Court. Now, I tried inspecting it last year in an interest of registers in general, and not only was it not affixed to the lobby of the Royal Court, it wasn't accessible as a paper copy at the Judicial Graphs reception. And so I'm very happy that this is being repealed, so data is kept up to date. And I'd make the wider comment, it's incumbent on all ministers to make sure that the registers that are established under them in statute are published, and some of them are big, some of them are small, but currently, clearly, registers, and in the context of the discussion the Assistant Chief Minister had yesterday about or on Monday on the FOI law and proactive publication of data, ensuring that this data is published in a central place is important. And I give note to one example again, that the Reservoirs Register and Records Jersey order sets up a register for reservoirs. And notwithstanding this being a statutory obligation, in 2025, the government replied to an FOI called Reservoirs in Use, saying that they did not hold a register of reservoirs. So it is important that we take this seriously, that the access to information is there, and I would like to use the repeal of Article 41 as an example to members.
Thank you, Deputy. Attorney General.
Yes, thank you. Perhaps I can accept Deputy Balash's invitation. He's right in the way he reads the effect of Article 6 of the legislation law as it would apply if the provision, which for the moment I've lost, this draft law is enacted. I understand his constitutional discomfort, but can I offer these thoughts, I hope by way of reassurance? What plainly would be unconstitutional would be for the UK to purport to impose on us its legislation without our prior knowledge and agreement. What is being proposed here is different in substance, which is it would be this Assembly, if this law is adopted, deciding in its own domestic sovereignty, because we are autonomous in domestic affairs, that for the purposes of deciding who is a person who is fit to practice in Jersey, it would give effect in reality to UK legislation. I take that to be, as I say, different in substance. It's a sovereign act of this legislature to take that decision. And it would be a sovereign act of this legislature to decide to amend or reverse that decision at any point if it saw fit. So I hope that's helpful.
Thank you, Attorney. Deputy Doublé.
Thank you, sir. I wanted to follow up on my panel member, Deputy Balash's point about the Care Commission, and it might be helpful to members if I gave some detail from the letter that we had from the Care Commission. And they have stated that the cost estimates are based on a number of assumptions. Some of these, such as the projected number of new registrants, have been provided by government. We have been explicit in our discussions with government that where assumptions are used, there is a risk that the associated costs may be underestimated. And whilst we do not anticipate significant additional costs, we have advised the Cabinet Office that the Commission would not be able to absorb any financial risk arising from underestimation. And of course, I did raise this during the in-principle debate, and the Minister in his summing up did give his reassurance that that would be the case, that any costs would be covered.
Thank you, Deputy. Deputy Brenoff.
Yes, also partly to respond to Deputy Balash's point, I think it would be helpful if the Minister could make it clear in very explicit terms the situation with regard to funding of the Care Commission for these. It was certainly the case at one point that we were told that there was a disagreement with the Care Commission about who would about where the funding would come from, and that there would be, that the Care Commission had said that they could not fund it from within their existing budget, and the government had said that they would have to. I believe subsequently that there were discussions that resolved this issue, but I think it would be very helpful if the Minister could resolve that in summing up. I would also just perhaps slightly disagree with or take a slightly different view to Deputy Balash in terms of the points about the UK taking a degree of sovereignty in relation to the registration of professionals, and see it from a slightly different point of view, which is, I think, the direction of travel, which I kind of welcome, is a greater integration into UK standards. And I have in mind the Maskey-Taylor report that was so critical of Jersey's elements within Jersey's health service that had strayed too far from accepted standards. And I think there's been a journey since then to correct that, and I think the articles in this legislation give some effect to another aspect of that, which is the registration of professionals. And I think the comfort that people who are coming from the UK to work in Jersey will feel that there is a shared regulatory framework which extends to registration, and I think that is a positive thing, and I think that degree of standardisation is welcome, not least because we know from the direction of travel that the Minister is pursuing in terms of treatments, partnerships with, I think it's 5 different bodies in the UK that we will partner with and send patients to on a regular basis, and potentially indeed have their experts come over to Jersey to treat over here. That integration does imply a degree of convergence in regulatory terms, and therefore I think that the sovereign decision, as the Attorney General has pointed, to align ourselves in that respect, with closer alignment to the UK, makes sense given the direction of travel of the policy framework within our health service. I hope that helps.
Thank you, Deputy. Deputy Talia.
Thank you. I was just thinking about only part of what we're debating here. It's only a small part, but I think Deputy Coles, obviously, and then followed by Deputy Balash, has now triggered, I suppose, a mini debate on a specific issue about Jersey's sovereignty, and it made me think that what we're debating here is a kind of ambulatory regulation that we often most see in financial services legislation, but we're here seeing it in healthcare regulation. And what we mean by that is effectively, and what the Attorney General helpfully referred to, is that I suppose the reality around where we're in hoc with a larger parent jurisdiction, and whereby our health system is so closely linked in so many ways to the UK health system, that effectively what we're saying is that we will subordinate ourselves voluntarily to their will, and also when they make changes they will automatically come in force in Jersey, and we don't get to have the debate and say over that. It just automatically comes into force because that's the decision that we've made. And that may be a pragmatic way to look at it. And I was trying to think of a reasonable analogy, and the first one I came up with was imperfect. So it's a bit like me saying I go home at the weekend and I've got a plan in my head about what I want to do, but I may get an indirect instruction from, this is all hypothetical, sir, from my mother-in-law. And she might say to me, it's a nice day today, isn't it? And I'm thinking, it is a nice day, probably a nice day to go out for a walk with the dog. And she says, it's a nice day to wash the car. Isn't it, Monty? And I'll say, oh, yes, that's right. And so I'll say to her, I'll think to myself, I am going to wash the car, but I'm not doing it because she told me to. I'm doing it because I want to, and it's my own decision that I've come to because I'm an autonomous person. And so I tell myself that, and then we've got a nice clean car for the weekend, and we're all happy until, of course, maybe the dog gets into it on Monday and it gets muddy again. but that's a different story. But that's slightly imperfect, and I thought, since we've, I certainly miss a couple of the old country constables that we used to have in the Assembly who used to give good food-related analogies. I won't mention their names necessarily, but we do need a good food-related analogy from time to time. And it's probably a bit more like me going into a restaurant, an exotic restaurant with a friend of mine, and I don't really know this type of new cuisine. So I say to my friend, I'm just going to have what you're having. And then he orders, and then I just get the same as what he's having, irrespective of whether that's good or bad. And then after a few times, I go into the restaurant, and I'm still doing that 10, 15 years, maybe 800 years down the line. And I still haven't decided what my own mind is, but it's okay because I'm voluntarily deciding to do whatever and eat whatever my friend is ordering. That would be a strange thing for somebody who purports to be autonomous, to simply defer to my friend, especially when I'm supposed to have my own knowledge and awareness of what that restaurant is serving. By now, I've been to it so many times, and also being supposedly autonomous. That doesn't really wash philosophically. So I think the challenge to the Minister in all of this, we've been told that the amendment from Deputy Coles wasn't the right one, but I think he does need to take into account, both either now or into the future, those examples of saying that the UK will not always have the best healthcare systems. We do have lots of very competent workers in Europe who are right on our doorstep. We've also got some great healthcare facilities right across the water in Brittany, in Rennes, for example, and no doubt in Normandy as well, where there will be workers who could come and work in Jersey in our hospital, provide work, and they may not be able to do that because of the requirements for us being so closely linked to the UK. And I think that is a challenge that the future Health Minister does need to provide some reassurance, not just to members in this Assembly, but I think to the wider public, especially given that we're seeing workers in healthcare come from further and further afield, and they're most welcome in Jersey because we do need them, and we do need qualified workers from all over the world, sir.
Thank you, Deputy. Does anyone else wish to speak in second reading? If no one else wishes to speak, I call upon the Minister to reply. Minister.
Sir, I'm tempted to say that I think I covered all the important points in my speech, but I will make a couple of comments. I'd like to thank Deputy Dibley for reminding members of the commitment that I made with regard to funding. I thought we had resolved our funding issues with the JCC, but if we haven't, I'm sure we're going to deal with them, because I think we really need a reality check here. Either we want to regulate health in Jersey properly, or we don't. And I think there's been an awful lot of naivety in some of the comments made. It's a little bit about more than washing your car or taking your dog for a walk. The reason we're trying to align ourselves with a single system in the first instance, because we haven't even got a proper centralised register of all the people practicing here. We're starting from a very long way back, and we're talking about having a pick and mix and a system where in the hospital we can have various people working in the same department under different regulations. I can't see how much more naive one could hope to be. We need to start from the simple base that we've got and work going forward. There may be a time when everything's perfect and we can very carefully select to go in a slightly different direction, but let's face the facts. We have to get our house in order in the first instance, and that's what we're trying to do here. I'd also like to thank the Attorney General for answering the question that I wouldn't have had a dog's chance of answering, and I hope that's provided some clarity for members. But I just make the point again, it's very important that we recognise where we are and stick to our guns and take a good, clear approach to things. So, thank you.
Is the appel called for?
Yes, sir.
The appel has been called for. Members are invited to return to their seats. I'll ask the greffier to open the voting. All members have the opportunity of casting their votes. I ask the greffier to close the voting. The article's been adopted in second reading. 41 votes pour, no votes contra, and 2 abstentions.
The two, please.
Deputies Moore and Wilson abstained.
Minister, do you propose the matter in third reading?
I do, sir.
Is the matter seconded in third reading?
Yes, sir.
Thank you. Does anyone wish to speak on the articles as adopted in second reading in third reading? Those members in favour of adopting the law in third reading kindly show. The appellant is being called for. Members are invited to return to their seats and ask the greffier to open the voting. If all members have the opportunity of casting their votes, I ask the greffier to close the voting. I announce that the law has been adopted in third reading, 41 votes for, no votes contra, and 2 abstentions. The next item is the draft termination of pregnancy law lodged by the Minister for Health and Social Security. The main respondent is the Chair of the Health and Social Security Scrutiny Panel, and ask the greffier to read the citation.
Draft Termination of Pregnancy Jersey Law 2000, a law to replace the Termination of Pregnancy Jersey Law 1997, to provide for the circumstances in which a termination may be legally performed and to introduce offences related to providing terminations outside of those circumstances. The States, subject to the sanction of His Most Excellent Majesty and Council, have adopted the following law.
Minister.
Sir, if I may, I'd like to hand over to the Assistant Minister who looks after women's health. Sir.
Yes, Assistant Minister.
Thank you, sir. Termination of pregnancy is a complex and sensitive subject that divides opinion amongst islanders, and I'm sure amongst some members of this Assembly. But today we are not debating whether termination should be legal in Jersey. It is legal. We are instead considering whether to adopt a new law which repeals our existing 1997 law and brings forward new provisions related to gestation limits, grounds for termination, offences and other associated matters. A new law which seeks to better reflect current societal values, take account of changes in clinical practice and meet the needs of women faced with a decision that for many, if not all, is one of the most difficult they will ever have to take. A deeply personal decision that, regardless of our personal views on termination, is not one for us to deny women the right to take. It was the previous Health Minister, Deputy Wilson, who initially commissioned a review of our existing termination law, with this Assembly deciding in December 2024 that a new law should be brought forward for consideration. The provisions before us today have been shaped by responses received to our Phase 1 and Phase 2 public consultations, through detailed discussions with on-island providers, and through examination of legislation in other jurisdictions. Both those consultations indicated strong support for modernisation of Jersey's existing legal framework, albeit some respondents expressing opposition to termination in any but the most limited circumstances, and with a wide variation of views of how best to proceed. What the new draft law sets out is not novel or groundbreaking. It is built on legislative changes brought about in other jurisdictions, for example, the UK, Guernsey, the Isle of Man, Australia, and Northern Ireland. Before I provide an overview of the key provisions of the proposed new law, I must address the matter of service limitations. This draft law, if adopted, will extend the circumstances in which terminations are legal in Jersey, but this does not equate to being able to offer later stage termination services on island. The provision of termination services require health and care professionals who are willing to participate, and as matters currently stand, only a limited number of doctors will provide the service. Furthermore, we need a workforce with the necessary skills and training. In the UK, post-20-week terminations, which carry risk, are generally provided in specialist facilities. Our services, even if Jersey were able to recruit staff with a specialist expertise, our small population size would inevitably lead to de-skilling over time. Our services must first and foremost be safe. We cannot extend on-island services, regardless of what the law permits, if we cannot assure safety. You might ask, why bother amending the law if we can't provide the service? But amending the law as proposed helps destigmatise termination. It says to women, you don't have to justify your decision. You have the autonomy to decide what is right for you within the legal gestational limits. Furthermore, it provides clarity as to when women may be referred to the UK for a medically necessary termination, and it allows us to provide an extended service if the workforce is available in future. So what does the proposed new law do? It allows a woman to have a termination on any grounds up to 22 weeks gestation, as distinct from the current 12-week limit on the grounds of distress. We don't have to force a woman to justify her decision by citing distress, because that is demeaning. It impinges on her autonomy and theoretically requires a doctor determining the presence of distress, as opposed to anger, fear, stress, or any other human response. The draft new law also permits terminations at any point in the pregnancy, i.e. beyond 22 weeks gestation, on limited grounds, including if the termination is necessary to save a woman's life, to prevent serious injury to her physical or mental health, to prevent significant risk to another fetus in the case of multiple pregnancy, or in the case of serious fetal anomalies. Terminations on those few limited grounds are commonly referred to as medically necessary terminations. Although I accept this language, like much of the language associated with terminations, can be disputed. The proposed 22-week limit for terminations on any grounds, as opposed to medically necessary grounds, is based on the concept of viability of life. In short, international consensus states that the end of the 22 weeks gestation is the cutoff for viability of life. In other words, a fetus born after 22 weeks may be born alive, even if that life is momentary. Different jurisdictions have made different judgments about gestational limits for non-medically necessary terminations. Some are more restrictive, such as the 90-day limit in Italy or the 14-week limit in France. Others have limits broadly linked to the viability of life, such as 22 weeks in Iceland or 21 weeks in New South Wales. Some, including the Netherlands and UK, permit non-medically necessary terminations up to 24 weeks. There is no straightforward or correct answer when determining gestational limits, as indicated by the decisions taken in these other jurisdictions. But a threshold has to be agreed, and the 22-week viability of life limit was supported by the majority of Phase 2 consultation respondents when taken into account those who support reform of our existing law. In linking our threshold of viability of life, we recognise that the threshold may change in response to medical advances. Hence, the draft law allows this Assembly to amend the 22-week gestational limit by regulations. As stated, the draft new law permits terminations at any point in the pregnancy in the case of serious fetal anomalies. Such terminations are currently permitted in Jersey up to 24 weeks gestation, but removing the 24-week limit brings us in line with the UK, Australia and New Zealand. Permitting terminations on grounds of serious fetal anomalies brings concerns about human rights, specifically regarding the rights of disabled people. But we must note that in 2021, the UK Court of Appeal ruled that termination does not interfere with human rights of disabled people or people with Down syndrome. Whilst the draft law defines serious fetal anomalies, unlike the existing law, clinical judgment is still required to determine when the threshold is met, i.e. when the anomaly is serious as opposed to non-serious, with doctors working in accordance with the British Medical Association, with the Royal College of Obstetricians and Gynecologists clinical assessment guidelines. In all cases, a termination at 22 weeks or more is only permitted if 2 doctors agree with the limited grounds for termination are met. Removing the existing 12-week limit and allowing terminations up to 22 weeks on any grounds provides women greater choice. That is important, but it is also the case that early terminations are generally safer. For this reason, the draft law seeks to remove barriers to access, including removing the existing requirement to consult 2 doctors, unless, as stated, the termination is at 22 weeks or more. A woman who is having a termination before 22 weeks need only consult 1 doctor, although that doctor may require a second consultation if they consider it necessary. If they are concerned about matters such as coercion, the woman's mental health or physical health, or whether the doctor wishes to exercise their right to refuse to participate. The one consultation requirement allows a woman to self-refer into the termination service as opposed to requiring referral via a GP. The consultation must be in person as opposed to by phone or video to better support confirmation of gestational age or allow identification of potential coercion or abuse. Unlike the UK, the draft law does not permit telemedicine terminations with remote consultation and abortion pills by post, as the same geographical access issues do not exist in Jersey. But it does allow the states to permit telemedicine by regulation or minister by order in the event of a pandemic or other time-limiting exceptional circumstances. In the case of medical terminations, the woman may take the medication at home or at another safe place in Jersey to help minimise anxiety, but the doctor must be satisfied the medication will only be taken in Jersey, nowhere else, in the event follow-up care is required. Any woman in Jersey may have a termination. There are no residency or age restriction, but the draft law, which requires a woman's informed consent, does set out how a doctor should proceed when the woman is a minor who does not understand the nature and implications of a termination. Our existing law is silent on all matters related to consent. Termination is a paid-for service in Jersey, albeit many women are exempt. Under 18s, full-time students, women in income support households, women whose pregnancy arises from incest or rape, and any woman who has a medically necessary termination, regardless of gestational period. There are known concerns about the principle of charging and potential impact on access to the service. Hence, while the Minister intends to retain fees, albeit set by order rather than policy, to provide transparency, those fees and the principle of charging will be reviewed later this year alongside contraception fees. health professional may refuse to provide terminations services or related services, such as acting as a theatre nurse, or anaesthetist during surgical termination. This right to refuse, which mirrors the assisted dying law we have just approved, can be on any grounds, not just conscientious objection, unless an emergency termination is immediately required to save the woman's life. The right to refuse is accompanied by employment protections for those who participate in termination services and those who do not. Employment protections will have particular importance if at some point in the future this Assembly adopts regulations to permit terminations to take place other than in HCJ facilities. For example, if another provider establishes a termination clinic in Jersey. The draft law also allows this Assembly or the Minister to decide in future to permit professionals other than doctors to provide medical termination services. This could include midwives, nurses, or potentially prescribing pharmacists, as is common in other jurisdictions. Thank you, sir. Our existing law provides that both women and doctor commit an offence if a termination does not accord with the provision of the law. In contrast, the draft new law states that a woman cannot commit an offence in relation to her own pregnancy on the basis that a woman who seeks an unlawful termination or attempts to perform one on herself is likely to be vulnerable and in urgent need of support and assistance, with any resulting investigation compounding her associated trauma. But this does not remove criminal liability from others, including healthcare professionals who act outside the law, or any other person who acts with intent to cause a termination, for example, by administering medication. This includes a person who acts without the woman's consent, with potential penalty of life imprisonment, or with the woman's consent, with potential penalty of up to 14 years imprisonment, or a fine, depending on the circumstances. It is similarly an offence to attempt to cause a woman to have a termination by the use of force, undue threat, or undue coercion. Importantly, the draft law also provides that it is an offence for a doctor fails to ensure a woman has been informed about the availability of counselling before their termination. Participation in counselling is not mandatory, but the Minister must, by law, provide counselling, and the woman must, by law, be informed about counselling. Sir, as I have previously stated, there is nothing novel in this proposed new law. It is built on the experience of other jurisdictions and accords with the views expressed by many islanders. It works to protect health and care professionals and to respect their views on termination. It provides a framework of regulation and orders that allows us to adapt the law in future, whether to increase or decrease gestation limits, change the grounds associated with termination, or permit other professionals to provide services. Last week, the scrutiny panel provided comments to the draft law, for which I thank them. They asked that we monitor the impact of the proposed new provisions with a view to supporting workforce planning, identifying and removing any ongoing barriers to access, and revisiting the issue of extending gestation limits for non-serious fetal abnormality. I commit to doing this in the knowledge that the framework of reporting requirements set out the draft law, coupled with the regulation and order-making powers, will allow this Assembly to take action if required. Further to this, the draft law also allows us to introduce safe access zones by regulations in the event we determine it necessary, recognising that in Jersey, despite the differences of view we may hold, we have the privilege of living in a community of people who respect the choices, beliefs and needs of others. Before us is a draft new law that is underpinned by current medical practice and better reflects the shifts in some societal values that have taken place in the 30 years since we first legislated for termination of pregnancy. Sir, I move this proposition.
Thank you, Assistant Minister. Are the principles seconded? Thank you. Does anyone wish to speak on the principles of the draft law? Honourable St Saviour.
Thank you, sir. I will be brief. I wonder if the Assistant Minister could assist me, as there are a few things that are bothering me. I fully defend the woman's right to choose. What does bother me is the 22 weeks, which is very, very late. There was extensive coverage of twins born prematurely at 22 weeks. Both mother and twins doing extremely well. Twins have put on a lot of weight, perfectly healthy babies. I think the Assistant Minister knows where I'm coming from here. This is a particular thing that's bothering me. Obviously, if there is some medical problem or the mother's life is in danger, so be it. But it's the late 22 weeks, which is 5.5 months, that does bother me. Thank you, sir.
Thank you, Conor Tarb. Deputy Dublé.
Thank you, sir. And it was a difficult decision for me to decide whether to speak early in the debate or later in the debate, because I'm really keen to hear all the speeches and to be able to respond. And the previous point gives one example, and I don't have time to fact check that, but I hope one of the other members might actually fact check that and respond to it. The Assistant Minister mentioned the scrutiny comments. I hope members have had a chance to view those, and I will briefly go over those comments. I just wanted to emphasise that we did have some variation amongst the panel in our views on this legislation, and the comments very much reflect that, and I took great care to make sure that all views were represented in our comments, as of course this is a matter of conscience for many. And so the comments that my panel have published make it clear that our current law, as the Assistant Minister has stated, is completely outdated, no longer fit for purpose. Even at the point of introduction, it was probably quite outdated, actually, because it replicated a 1960s law from the UK. And that element within the law of having to be in distress in order to access a termination is one of the most egregious parts of that law, actually, I think, because women need to access terminations for all sorts of reasons, and some of them, and I think distress is probably one of the things that may be experienced by a woman, but also it can be a perfectly rational decision based on perhaps consideration of existing children and ability to care for them, and things like cost of living pressures. And I wanted to note actually that I'm aware that in the islands there are islanders who are accessing terminations because they cannot afford to have children, and at times there are pregnancies that are wanted but are not affordable. And I think that's something that we must take very seriously, and I know that the next government will have to tackle the challenge of making this island more family friendly. So the panel found that this law does reflect the intention of the Assembly. It gives effect to the budget amendment that my panel put into the previous budget, which was supported by the Minister and by the Assembly to bring forward such a law. It's based on some very thorough consultation. In fact, 2 rounds of consultation, which I don't know if members had a chance to look at those consultations, but very, very fine points of detail in that consultation, weighing up the different elements in the law, and in my view, a very well conducted consultation. And we've been grateful to be closely involved in the process of the law being developed, and we're grateful to the ministers for that. There is strong public support for modernising this law. That's something that is very clear, and indeed strong stakeholder feedback from professionals as well. And this law is evidence-based and is a good law. We did find that, albeit the Assistant Minister has clarified to us that terminations beyond, I think, 12 weeks may not be able to be carried out on islands, that might be something that changes in future. But changing the law does provide the clarity to professionals so that they know what is actually allowed in the legislation and what is okay. And the law needs to come first, really, doesn't it? So I think... and this is kind of aside from scrutiny, I personally do feel that it is important that we work towards providing that service genuinely in Jersey, and I hope that the health service will be able to perhaps actively look for clinicians that could provide that, because of course we must respect the existing clinicians who have said that they don't want to do that. We must respect that, and I think it would be worth actively recruiting so that women in Jersey do genuinely have options. But of course I note that most terminations, I think it's in the high 90s, most terminations are performed before the 10 weeks, which would be a medical termination using the medication. So we're clear that despite the fact that the services can't actually be expanded at the moment, the legislative reform is appropriate and it's necessary. And I thank the Minister and his officers for clarifying this in our public hearings as well. This law change, as the Assistant Minister has mentioned, will reduce stigma, and I think that we cannot understate that actually, because the feelings that we talked about, the distress and perhaps other feelings, can be amplified where you're in a jurisdiction where actually the law is different from many others, and that can cause actual psychological harm to women who are in that situation. In terms of the future modernisation, there are some things that we've identified. Again, the Assistant Minister did mention some of these. And I want to emphasise that our main concerns are not around the principle of this legislation, but just some small things around the kind of implementation and the future workability of the law. Counselling. So we talked about counselling services, and we note that counselling, it has to be suggested, the information has to be given. What we couldn't see in the law was how soon would it actually be available, because of course if you're making a decision about accessing a termination, you would want to access counselling within days, really. So this is something that I would be grateful if the Assistant Minister could address, whether that counselling is going to be genuinely accessible within a very short time frame, and will that counselling be culturally sensitive? Will it be trauma informed? And will there be robust training for those counsellors so that they can offer the type of counselling and be flexible enough to offer counselling that is necessary? And also, will there be counselling available to women post-termination and to women who access the termination off island? And I can see the Assistant Minister nodding, so I hope that she will address that when she responds to the Assembly. We also flagged about remote access to consultations. And I will come on to that a little bit later, because I am going to talk about my own personal views as well as the scrutiny view. The cost of terminations stands at £185. And actually I looked back at the proposition which I brought to the Assembly, which I think was in 2021, to remove the compulsory 7-day, I think it was called a cooling off period, which is extremely offensive, but it was at the 7-day waiting period that women had to endure before they could access a termination. And the cost at that time was £185. So it is good to see that the cost hasn't been raised, but it's a lot of money, especially when you are facing obviously difficult circumstances. And if you're accessing a termination because you do not have the financial means to raise a child, then £185 is a huge amount of money, and it is also a barrier to any women who are being abused. And we know from the Vorg report that financial abuse is a feature of the vast majority of domestic abuse cases. So women in those situations, and of course sexual abuse might be a feature of that abuse, which might result in an unwanted pregnancy. So there are interactions there which I think have not been adequately addressed, albeit I do acknowledge, and the panel does acknowledge, that the Minister has given us a list of criteria that she, by discretion, offers that service for free, which I think includes islanders who are in receipt of income support, young people. I think the Minister mentioned some other criteria. I personally, and this is my personal view, I do think that should be expanded. And I think that one of the criteria that should be on that list is being a victim of any type of abuse. And I also feel that single parents should also be able to have that discretion, if the Minister could consider that. Sorry, I'm slightly jumping around between scrutiny and my own views. I will return to the scrutiny comments now. And so when we looked at the cost around this service, we did also discuss the cost of contraceptive services. And again, there was a range of views on the panel about this. Some of us felt that actually contraception should be offered entirely free of charge. Other panel members felt that there should be perhaps some charges for those who can afford to pay. That was an interesting conversation. And what we've recommended in our comments is that actually termination of pregnancy itself should be offered free of charge, and that should be as part of a comprehensive and equitable reproductive healthcare system. So equity meaning that those who need to access contraception should be able to do so, and those who cannot afford to do so, I think, should be able to do so free of charge. And this should form part of the women's health strategy work, the ongoing review. So the panel are cautiously supportive of these reforms, and we recognise that it's a really important step. It's a progressive step for Jersey, but we do emphasise that the effective implementation and operation of the law should be very closely monitored to ensure that the intent of this legislation is fully realised in practice, and that all women and girls experience safe, timely and equitable access to services. So we recommend that monitoring and evaluation and an ongoing review of the law are incorporated into the development and the delivery of the women's health care strategy. Because of course there are various different touch points at which if you don't have a wider women's healthcare strategy that is robust and delivering effective services, that actually termination services might be less needed if the other services are improved. So if that could be considered, we would be grateful. Workforce capacity should be considered, counselling availability, cost and access pathways should all remain under continuous scrutiny. And so we also discussed the gestation limits, and we noted that the proposed limit of 22 weeks is based upon viability. And I'll talk a little bit more about this in a minute when I take my scrutiny hat off. One thing that the panel did agree on in that respect, and of course, whenever we're having any kind of ethical discussion around termination of pregnancy, the point that I think becomes the ultimate ethical point to consider is up to what point should termination services be reasonably available on demand. And what my panel did agree on is that if there is to be any change to this whatsoever, that it needs to be presented to the States Assembly and given full consideration by the States Assembly. We also felt that off-island care pathways should be very clear to anybody who needs to use those. I think that I have covered adequately all of the scrutiny views, but I'm sure my panel members, when they make their speeches, will cover anything that I may have missed. And so I would like to take my scrutiny hat off now, and I'm going to again say to the Minister that I welcome this legislation very much so. And last term, when I was a backbencher preparing my own propositions, at the end of last term, I had a piece of work that the culmination of several months of work and consulting with professionals and different bodies, and I had a proposition that was ready to go to request the Minister to reform this legislation. And luckily, when the new government was assembled at the beginning of this term, I had some conversations with the previous Health Minister, and she was very much in agreement with what I wanted to do. And I had some discussions with my kind of co-assistant Minister for Home Affairs, Deputy Jean, and we were very lucky to be able to have an early input into that. And I sent that draft proposition directly to the previous minister. So grateful in a way that that was taken on board. And the list that I had in that proposition, I compared it to what is in this legislation. And there is one thing that is missing that I would like to highlight today. Not completely missing. It is mentioned as an area for future development, and I've mentioned it briefly when I touched on the scrutiny comments, but it's the remote access to consultations. And again, this is something that I campaigned for during COVID, when I realised that there were no such facilities available to women, and which led in effect to there being no facilities to access termination services at all, which was quite alarming. And after some campaigning on that and discussions with the minister at the time, that was changed fairly quickly, actually. And so I know it can be done. And I do wonder why this option hasn't been offered as part of this legislation, because I feel that it really should have been. And one of the biggest reasons why I believe so strongly that that should be offered, that women should be able to access a remote consultation to access termination services, is because of the issue that I mentioned previously about women who are in abusive relationships. And a woman who is in an abusive relationship, her movements are often restricted. She may not have access to transportation. She may not have access to her own money to pay for a doctor's appointment. She may be being tracked. Her location might be being tracked on her phone. And all of those barriers which can be experienced in an abusive relationship, also the financial abuse, she might not have her own funds, can limit a woman's access to termination services. So I feel quite strongly that that should be offered, and I hope that the minister will be able to consider that, and it's probably for the next minister now as part of the ongoing review of this legislation. But it is something I feel would be necessary. And I just wanted, sir, before I finish, to just reflect on campaigning, because of course it's not just us in this assembly and the women, perhaps, who are part of the Women's Health Steering Group, I think it's called, who have helped the minister to develop this, and the officers. It's also decades of women campaigners beyond our island who have fought for the right to access termination of pregnancy services as a basic healthcare right. And what we know from the evidence is that if termination services are not accessible in a safe way, in a medical environment, termination still happens, and women suffer and die from it. So actually the legislation is not going to be causing any more terminations, it's just providing for safe terminations. And I wanted to remind members that the vast majority, maybe the Assistant Minister knows the exact number, it's in the 90s, isn't it, the percentage of terminations that are the medical terminations, which I think is 2 sets of medication that you take a day apart, I think, and is something that is not perhaps what we are led to believe by campaigners who have a certain view of this. And as a humanist, sir, I did talk to some of my humanist friends about this and colleagues, and there's not always an agreed view amongst humanists. I had some interesting discussions about this, but actually what humanists do tend to defend is bodily autonomy, and a woman's right to choose is something that came through very, very strongly on this. And I think that is all that I have to say, sir. But one thing I will finish on, actually, is that whatever view people have on this, I think that we all can agree that human life is precious, and we must remember that a fetus, that is a potential for life, yes. But we must also remember the life of the woman who's carrying that fetus, and actually her life is precious as well. And I do understand how precious that potential for life is, having experienced pregnancy loss myself, and I know that there are others in this assembly who've experienced that, and there will be members of this assembly who maybe feel this debate in a much deeper way than others, and have experiences. And I have actually forgotten one point which I wanted to make. The scrutiny panel, where we did receive some evidence around the 22-week limit, which really struck me, actually, because, and this is why we recommended in the report that any change of that limit should come back to the Assembly. And I think the Minister has awareness of this issue as well, and I hope that she will consider it, because I think that there is a genuine need there, that at the 20-week scan, that will be the time where a fetal abnormality will be detected. And what we are doing with a 22-week limit, which is different to a 24-week limit, which the UK has, is we are restricting that period of time that the woman and the family have to actually decide what to do and what action to take where that fetal abnormality is detected. And that, Sarah, is something I don't have experience of, but I can only imagine that that is a horrendous decision to have to make, and 2 weeks is just not enough time to make that decision. So I feel that that's something that needs to be part of the review that the Assistant Minister or the next ministers do on this legislation, and it needs to be taken really, really seriously, because even though it only might occur in a very small percentage of pregnancies, it really matters to those families where it does occur, and I want their views to be taken into account, so I hope that the Minister will consider that. But to conclude, so I support this legislation personally, and my scrutiny panel also supportive.
Thank you, Deputy.
So I was going to ask a point of clarification.
Prepared to accept a point of clarification, Deputy Blaive? Prepared to accept a point of clarification, Deputy Tadier?
Yes, sir.
Yes, I might have missed it, because I know the member said she was going to talk about viability on a personal capacity, not necessarily with a scrutiny one, but did the scrutiny panel consider whether viability as the basis for setting a limit of terminations is the correct starting point?
We did consider that, and there were panel members who raised significant concerns around that point of principle. And personally, I don't feel actually that is that should be a reason for setting that limit. I don't think that the viability principle is actually what we should be basing it on. But I do think that we are where we are with it. It's an improvement on the current legislation, and on that basis, I would support it at this time.
Thank you, sir. I did receive a communication from a parishioner on the...
Are you speaking?
Yes, sir.
The next person to speak was Deputy Miles.
Oh, sorry.
Deputy had something else to say. Deputy Miles, you're next on the list.
Thank you, sir. Apologise to the Connotab.
We'll be next to the Connotab.
You know, we've recently debated assisted dying, and I had absolute clarity on that debate due to personal experience, and I find this debate very difficult. And whilst I'm undoubtedly pro-choice and view this draft law as a matter of reproductive health, I have other emotional considerations which have led me to consider this proposition very carefully. My late brother was born with Down syndrome. He died of a congenital heart condition as a child in Jersey many years ago. But that familial relationship prompted a cascade of intervention in my own pregnancies, so that I have got some personal experience of the stress caused to parents at a very sensitive time. And I'm also a founder and a former trustee of a local disability charity, championing a full and inclusive life for members and support for their families. So when we debate termination of pregnancy due to fetal anomaly, we're addressing a very complex area of public policy. It involves difficult ethical questions, but it also involves practical realities that families must confront. People will hold different views on the issue of termination itself. However, regardless of those views, there is a responsibility that I want to raise, and that is the level of support available to families raising children with disabilities. The principle is already recognised in other areas of healthcare policy. In our recent debates about assisted dying, we argued that high-quality palliative care must be available so that people are not driven toward assisted death because adequate care and pain relief are lacking. Indeed, we passed an end of care law to enshrine those commitments. For me, the same logic applies here. Decisions about termination should not be influenced by the absence of reliable community support. If families want to feel able to continue pregnancies following a diagnosis of fetal anomaly, then the necessary medical, social, and financial support should be in place to enable that choice. When a diagnosis of fetal anomaly is given, parents will consider what the future may involve. And they're not only processing medical information about their child's condition, they're also assessing whether the systems around them will provide the support required. Parents consider the likely need for ongoing medical care, specialist consultations, therapies, and assistive equipment. They will consider whether their home will need to be adapted, whether appropriate education will be available, and how they will manage employment alongside caring responsibilities. For that reason, the availability and reliability of disability support services should be recognised as a key factor in discussions around termination of pregnancy due to anomaly. If support systems are underfunded, difficult to access, or inconsistent, families will inevitably take that into account when considering their options around termination. And so I think we have a responsibility to ensure that if families decide to continue with the pregnancy and to raise a child with significant additional needs, then the necessary structures must be in place to support them. And that means properly funded services. It means early intervention programs that improve long-term outcomes. It means education systems that are funded and equipped to support children with additional needs in a meaningful and practical way. It means respite services and short breaks that allow families to manage long-term care responsibilities. And it means financial support that reflects the additional costs associated with disability. I don't think that these issues are actually peripheral to the debate. I think they're part of the context in which decisions about termination due to anomaly are made. If the objective is to ensure that families feel able to continue pregnancies where serious conditions are diagnosed, then our policy response cannot focus only on legal frameworks. It must also address the infrastructure of care that follows birth. So in closing, sir, I want to recognise that the lives of people born with disabilities or congenital conditions are not defined solely by their medical challenges. Families often speak not only about the challenges they face, but also about the perspective, resilience, and value that these children bring into their lives and communities. Many individuals with birth defects lead lives that are meaningful, productive, and full of relationships, achievements, and joy. I am a big fan of Strictly Come Dancing, and I was filled with joy at watching a young woman with Down syndrome dance in that competition. When Ellie danced, her Down syndrome simply disappeared. And women like her challenge assumptions about what people with disabilities can achieve. So, as I said, sir, I find this very difficult. I will be supporting the proposition, but I wanted to ensure that I placed on record another perspective of a very complex issue. Thank you, sir.
Thank you, Deputy.
So may I propose the adjournment?
Members content to adjourn now? The Assembly stands adjourned until 9:30 tomorrow morning.